Good morning from Central Command of Home Coach in Raleigh, North Carolina. I hope everyone's doing well. You got through your orientation on there. So thanks, guys, for being ready to rock and roll on today's BICUP class. Y'all excited about it? Y'all look like the worst dang morning crowd I've seen in like ever. Come on,
Good
wait.
morning.
Amy's got a good smile. Thanks, Amy. Jenny, you
Morning.
thrilled as always, Jenny Purnell. Thank you guys for.
Good morning.
Look, you're going to have to keep me entertained as well, y'all. This has been a long year getting this stuff through. So I know you guys are excited to get this done, and it's not like you didn't wait till the last 60 hours to get it done. So we're all good to go. We got plenty of time to knock this out and get through. So hopefully, let me see with some thumbs. Can you see my screen share? Just show me some thumbs up there. Okay, good. Perfect. Outstanding. All right. So, you've got your $45 you got to get ready to pay by the end of this month. So I'm about to show you what that $45 gets you. You ready? Get ready to listen. Here goes. There it is. $45 to get you an intro into BICUP. Money well spent. Are you excited to go write that check, send that online payment in? Whew. Well, that's the theme of this is staying on the right track. Let's make sure we got everyone in here. You got to be a BIC or BIC eligible. If you're not, you got to go take another course, and you got a short amount of period of time to find it with someone else, because we don't have any more gen up classes left. So this is the last BICUP class of the season for us. So we're glad that we got you all in on that. If you aren't a BIC, please reach out to that tech number, Colleen or whatever, and she'll be able to help you at least try to find possibly another class somewhere else. All right. This is some COVID reminders that are on there. I understand COVID, it's been a rough time for a lot of people. I lost my mother and sister last year. So I get it. COVID, extensions and stuff, everything to do with COVID regarding your real estate license went away on April 11th. So if you're not sure at this particular juncture, and we've had folks that have been in the situation where they thought the credit was going to this year's season, but it ends up they didn't take it last year, so it's going to last year's. Anyway, anything to do with the COVID extensions, you need to actually contact the Real Estate Commission directly on that. We don't have anything or any control over any of that stuff. Okay. I just told you about, CE. Well, if you haven't gotten your elective done, you got to make sure you get your elective done by 11:59 on June 10th. 11:59 on June 10th. After that, if it's online, it's all going to shut down. It shuts down at midnight. Any of the servers that are out there with online courses, it cuts off. That's by Real Estate Commission rules. So let's see. We told you about paying. So we got a team behind the scenes on that. Why is that important, guys? Well, for a couple of things. One, let's just talk about logistics. If something goes down, if I go down, if I freeze up, sometimes this happens. We've got some storms that are across the state. You might go down, you lose internet connection, you jump back on. Same thing might happen to me. That's why we have several people that are on in order to keep the room live for you. If I freeze up or something, I'll hop back on. Colleen is a licensed instructor as well. That's why she's on this Zoom as well. We always have 2 instructors just in case that happens. And then we have some other staff that are behind the scenes, making sure everyone's checking in and stuff like that too. The chat, I think Colleen's mentioned to you about the chat feature. Let's talk about going through the class. I am not going to refer to the book all that often. So if you've got multiple screens or you're trying to navigate what things are you going to have open, the PDF, I'm going to maybe reference a page which you could write down or something, but mostly it's going to be the chat, us chatting, and on the share screen. Okay. The other thing that's going to help is as I'm talking and going through some stuff, you guys we've got a room full of BICs. And so use the chat feature. If I say something and you miss something or you had a question about it, you all can help answer each other on that chat. It's a great feature. I highly encourage you guys to be able to answer stuff and talk to each other, share it out there on the group. I don't usually see, I have a screen for the chat. I don't get to see it while I'm giving the presentation as much on there. So I'm not flowing it. Usually what happens is during the breaks, my staff is going to send me some things. Hey, Steve, you ought to pay attention to this question or answer this question. So that's when I get caught up on some chat stuff on there to go. Our folks off screen will help answer questions. So if you're asking for links or stuff, or they might send you references to the book while on the chat feature. Okay. So it's great. Please use it. This is just talking a little bit about our instructors. If you take other courses, every one of our instructors are a broker in charge. They're also all producing agents out there. That's one of my requirements for all of our instructors out there. A lot of you guys are returning, so that's great. You know us. We appreciate you coming back. All you newbies, thanks for trying out Home Coach. We really do appreciate your business. At the end of this class, you'll get a survey. Please, everyone, fill it out. This is how you guys have been phenomenal this year, have really grown our business. We really appreciate it. Please fill out the survey so we can make it better next year. A little bit about me, whatever. Let's say 24 minutes. I'm sure they talked about the 24 minutes in the orientation part on it. Guys, this is really important. We've had, there's unfortunate times. You don't have a chance to recoup this. Meaning if you don't get credit for this BICUP, you're not going to get, your CE is going to go inactive because unless you're able to find something last minute for tomorrow. And I say that because unfortunately we've had some folks, now remember this is being recorded. We've had folks who've been on screen who have challenged someone who is on screen saying they're not the person that they're on screen. We've had to send this to the Real Estate Commission. They investigate, look at the film. We've had folks who have literally come off of third shift at the hospital and have fallen asleep, drool's coming out of their mouth, and they don't get credit. Okay. You got to stay on screen. The worst offense, guys, is going in a car. Don't do it. You can't do it. You wouldn't be driving in a car if you were in a classroom. So I'm just putting that out there. Just make sure you stay on camera. I'm going to keep you awake out there. It'll be fun. We'll have a good time. Remember, you're on camera. Okay. We're going to, at 10 minutes till, we're going to take a break. Don't take your phone or whatever you're using into the bathroom with you. Don't do it. Don't go into, you think, I'm laughing. I see Terrence Thomas shaking his head. You know why? Because people do that. They go in and we're seeing it and it's recorded. It's crazy. And so don't go into the refrigerator and stick it in the refrigerator. You can go off screen, just leave the screen. You can actually take off the video when we go on break. And then when you hear my voice, bring it back up. I'll start back up at the top of the hour. Then you can click the video back on. Okay. Ain't nobody want to see you go to the bathroom. Just telling you, ain't nobody want to do that. 10 minutes. We'll go to the break. Already talked about questions. If you have questions on it, guys, we got a good sized group on here. You can ask questions that I think would be appropriate and other people to kind of fill you in. Maybe you missed something on the chat. If you got a question for me, you can raise your hand, but really, as long as we're all working pretty good, and it's been working great over the last year, is if you give a shout out, say I've got 25 people at any given time on a screen in front of me here. Okay. And so I've got a bunch of screens all around me. If you give a shout out, if Dina Paul just wants to go ahead and has a question, she can just say, hey, Steve. And then that comes right to the front of my screen. So I get to see Dina and then she gets to ask her question. Okay. So that it works out well. If we're all really good at it, it's a great way of doing it. So at the breaks, I'll throw up a poll question on it. It's just a fun thing for us to discuss. It's just a true, false kind of a question. So just be aware that that's going to be on there and we'll share that data with you guys. You got the text line, let's see. We already talked about, let's see. If we put up information all the time on Home Coach School. So if you guys want any kind of information out there, we're doing it out there for you guys. It's only for brokers. All right. So this is important. Let me, today, you're going to complete it on the 8th. It is not going to show up on your personal portal by June 10th. It's not going to happen. Okay. The way this works is that we're going to transmit to the Real Estate Commission. They take that information and scrub it. Okay. And then they post it to your personal portal. It can take them, they have said, up to 30 days before it shows on your personal portal. Okay. So it's not going to be there by June 10th. Do not freak out. Do not call me. Do not email us. Nothing's going to happen. We're not going to address anything until June 20th. June 20th. That's 2 weeks. Okay. And don't look at, I see Michael Giles. I see Mike's giving an eyebrow up and everything like this. There's nothing we can do about it. So, you will get a certificate. You've completed the class. You'll get a certificate before June 10th. So don't worry about it. We'll send you that certificate. Just don't worry about the fact that it's not showing up. If it's not on your personal portal by June 20th, you have to email me personally. That's why that email is on there. No one in our company can help you but me. Okay. Don't call the front desk. They're not going to be able to help you. Don't leave voicemails. I need an email saying it's not showing up so I can contact the real estate commission. I'm the only one in the company they'll talk to, and I can help you out. Okay. So it's steve@homecochnc.com. All right, cool. Folks off camera. All right, here we go. Similar to last year, we also, each section is going to start with a little vignette that is going to have a question after. So that's going to happen with each section. For today, you guys there are 6 sections for you. The first 2 are going to dominate the conversation today. The first one is going to be fair housing, which will take us past the first break towards the second, maybe even to the end of the second. Fair housing is something, if you're a realtor, NAR has been talking about since last year, but we've gotten some federal guidelines and stuff that have come out as late as March 1st that I'm going to introduce to you. That's not actually part of the course, but I'm going to update and bring it to your attention on that. So fair housing. The second one is going to be contracts. We're going to be talking about contracts. Complaints are up 300%. A lot of them are because of contracts and what's happening out in the crazy, insane real estate environment that we're having today. Then we're going to go into cybersecurity for a little bit. Then there's your topic, the broker and charge topic, which is going to be with regarding provisional brokers, and then law rule updates and licensing education. We'll wrap it up. Okay. All right. So you all ready? All right. So here we go. Get ready to listen, because the first vignette's going to come up.
Betty hires Ray, a broker, to assist her with locating a tenant for her basement apartment. Betty informs Ray that the tenant is not allowed to have a pet. Ray places an advertisement on social media and indicates that pets are not allowed for this rental. Ray receives an application from an individual with a service animal and reviews it with Betty. Even though the prospective tenant meets all the qualification requirements, Betty tells Ray she will not rent the apartment to the tenant because of the animal. Ray informs Betty that she's in violation of the Fair Housing Act and state fair housing laws.
All right, so we got a scenario, right? We've got an owner of a property who decides they don't want to have a dog. We have someone with a service animal. She refuses to rent, and then the property manager says, "Hey, you're in violation of the Americans with Disability Act." So the question for you guys is Ray correct? Go ahead and use your chat feature and just say yes or no. Is Ray correct? All right, George Wombo. George, hey, welcome, George. Welcome back. What do you mean it depends?
Just trying to be different. So,
oh, well, hey, it brought you to the forefront. So welcome, George. So, do you have...
I'm actually Morgan, but my first name George. I go by Morgan.
Okay, Morgan. Tell me why.
I don't know. I mean, I'd like to think that obviously if it's a service animal that you'd have to let them rent that, but at the same time, I feel like the property owner, if they're allergic to pets or something like that, that could be an issue as well. So I'm not sure.
Okay, no, well, so stay with me, Morgan, on it. So let's and we're going to challenge you guys to think in this class. Okay. So Morgan, tell me what do you think a service animal actually is, like by definition? What do you think that means?
I guess it's something that the person has to have with them. I mean, depending on their disability or whatever it is, it'd be something that they have to have. But I've also heard of lots of instances where people have service animals that maybe are not actually service animals, but the people are, say they are, so they can fly on planes with them and things like that. Like you see the service ponies and the all sorts of, service animal could be any kind of animal, I guess.
Okay, so let's clear something up too, and thanks for bringing that up, Morgan. But stay with me on it. Is that a service animal, folks, is only one animal, and that's a dog. Okay, and so there's differences, and we're getting ready to get into some minutia. So you're going to have to start thinking here on this. Is that on the service animal, it is a dog. It used to be, and Morgan, you actually said something. It was like a pony. And it used to be, you're absolutely right. It used to be a miniature pony and a dog. They got rid of miniature ponies, I guess, because, they didn't fit in taxi cabs in New York. Okay. So they got rid of that. So miniature ponies have been gone for about a year and a half now. It's just strictly dogs. And those dogs have got to be licensed, trained dogs. And they're the ones who you would be familiar with wearing the vests, right? And they're only for certain described ailments like blindness. Okay. Now this is the key part here, guys, is that, Morgan, in our industry, there's terms that we use that have kind of multiple meanings, right? There's a legal term, and then there's the term we kind of use like closing, right? When we talk about closing, Morgan, we're usually talking about like when we're actually signing and getting paid, right?
Right.
Closing to the law actually means when it gets recorded. Right?
Right.
Okay. So when we're talking about service animals, that primarily falls under ADA, Americans with Disability Act. Okay. Now, ADA has some bleed over into fair housing. Okay. So now, and that includes with this service animal, but it's designed for commercial property. Okay. Now, we say commercial because in real estate, anything other than a single family, duplex, tri, or quad, anything other than that is considered commercial. Okay. So you have residential, which is single, du, tri, and quads. Okay. Everything else is commercial. However, in the law kind of thing, the commercial property we look at, like apartments and property management type of stuff, that's actually applied to residential. You with me, Morgan?
Right.
Okay. So with the service animal, which is the licensed and prescribed animal, let's start on the commercial side because it's kind of the easiest. ADA applies to the commercial. They're the ones who dictate the wide hallways, in your commercial buildings, the bathrooms that have, certain stall sizes and everything. Okay. That's the commercial side. That's what ADA does. So if you take your favorite grocery store, Harris Teeter or Whole Foods or Lidl, whatever it is, right? When that blind person walks in with that service dog, that dog is no longer considered a dog. It's actually considered part of the person, like their right arm. Okay. And so the Harris Teeter can ask and say, is that a licensed service animal? Right? If the response is yes, it is, then Harris Teeter must, that's a must, let that dog and that person in. Is that fair enough?
Right.
Okay. So I want to stop there for a second. And Morgan, hey, everyone give Morgan a hand just a sec for being the first guy up and out of the block there. He won't offer to say anything else again, I promise you. So, thanks, Morgan. You can go ahead and mute up. All right. So I want you to listen to the next vignette, okay?
John owns a residential house and decides to use it as a rental property. In his advertisement, John notes that no pets will be allowed in the property. He receives several applications and evaluates each based on employment, creditworthiness, and criminal history. He selects a tenant and notifies the individual that the application was approved. 1 week after signing the lease agreement, the new tenant emails John and asks for an accommodation for his assistance animal, a pig. John denies the request, stating that, number one, the pig is not domesticated and may damage the property, and number two, the tenant did not request the accommodation prior to signing the lease. Can John legally deny the accommodation request because it was submitted after
Okay, guys,
the
this is where you're going to use
application?
on your chat feature. So you got the scenario. They took the application and said no pets. They come in, they get the approved, and then a week later they say, "Hey, I need a support animal on that." He says we're gonna deny that or kick you out. Is he correct? Can he do that? He can deny. And man, it starts off with Chris Anderson says yes. Go ahead and say yes or no. Can he deny? All right, Amy Hoyt, tell me why you said yes.
Well, I thought you said it was dogs only.
Okay, okay, fair. So you're trying are you trying to use what I said against me? Terrence is agreeing with that. I see Terrence shaking his head. Yeah, yep, trying to say that. Well, is it a different scenario? Is there a difference between service animals, Amy, and assistant animals?
Oh, I would guess so. Yes.
Okay. All right. Just pause there. I'm going to see if Larry DeHart, can you you said yes too. Tell me what you think. All right.
I would say that she did not designate what her disability was, as you stated, only dogs. And I think he's right in refusing the rental.
Okay. So thanks, Larry, and thanks, Amy. Let's start with a premise that, like, when it comes to, so there's a difference between Harris Teeter and commercial and housing, fair housing. Okay. Jim Burns, I'm going to be coming back to you, so you be prepared, brother.
I will.
So there's a difference between commercial and housing. And say as a country, now we want, whether we do it good or not, whatever, we're not going to debate, is housing, clothing, and food. We try to make sure people have that available. So when we're looking at renters, tenants, the laws are going to lean towards the tenant, right? So because as a country, state, municipalities, we're looking at, well, we want people housed, okay? And the owners of those properties are using that as a business, okay? So if you're a property owner and you're renting out, you're running a business. So you're going to be treated as a business owner versus someone who's trying to live, under a roof. Okay, so the laws are slanted. So that's why when we go to housing, it's going to start to move more towards the actual tenant when we're talking about rules. So let's look at service animals. The same thing. Let's go to the first scenario that I was talking to Morgan about. And you have the service animal dog. And Amy says, hey, well, you said dog, Steve, right? And that's correct. With a service animal that's licensed and all, that same thing applies. The same rules that apply to commercial would apply to housing. Okay. So if that blind person that went into Harris Teeter now shows up to your apartment complex and wants to rent, okay, that dog is not considered a dog, right? We've already said that. It's considered like the right arm of the person. Okay. So we have to let that person with that dog in. Just as long as the person qualified, meaning, from your income and all that other kind of stuff, qualification, you have to let that in. So let's take this particular situation. Now we have a what's called an assisted animal. Okay. Hey, Mary, go ahead. Is that we have an assistant animal. The assistant animal is now a broad definition. This is kind of where Morgan was kind of blending what we call service animals with assistant animals. Assistant animals have multiple names for it. They're emotional support animals, they're comfort animals. These are some names that are out there. These assistant animals help people in various reasons. Could be emotional or whatever. Now, the rule on it is they can be any domesticated animal. Okay. Domesticated cats, dogs, birds, snakes, hamsters, anything, and a pig, potbelly pig, is a domesticated animal. So a person comes in and says, I have an emotional support animal, or I have an assistant animal, then that animal is going to be considered just like that part of the person. Are you guys tracking with me so far? Chris Senf, what do you think? Chris, can you hear me? Let me go with Roxanne Levan. Roxanne,
Hello.
what do you think about what we're saying so far? Is it pretty understandable?
Yes.
Okay, so what do you think about in this particular situation where what we have is someone who now they've applied without the dog, and then a week later they come back or it's a pig actually, they come back a week later and say, I want to bring my pig in. What do you think about that?
Well, if they've had a doctor give them a letter within that week that they have to have a support animal, then that's a different story.
Okay, so right. So you're saying that's fine, right? Is there
Yeah,
anyone who okay? Is there anyone who disagrees? Anyone? Brenna Ocampo, what do you think?
Sorry, I'm not sure, so I'm
Yeah, what's your gut?
agreeing.
What's your gut say?
I mean, if I know that it's different, and it's just animal's different than a service animal, so I'm not entirely sure if they had a doctor's note, if that would be protected or not.
Okay, all right, fair questions,
can't
guys. So
ask.
let's explore this.
Can I
It
answer
doesn't
that?
it doesn't matter that it came a week after. Okay, right. So I'm ex. Let me give you an example. I'm ex-military. Our son is a ranger down at Fort Bragg, military. So we happen to know folks that are suffering from PTSD on it. And so let's say this person rented from you, and then a week later gets diagnosed with PTSD. Okay, now it doesn't have to be signed by a doctor, but they come to you and say, hey, I have a service animal that I need to help with. Not a service animal. I have an assistant animal, emotional support animal for my PTSD. You can ask them for some verification that they actually need this animal. That's fair. Okay. You can't ask them like, well, how long you'll be dealing with this PTSD? You can't do that. Okay. Now, the document that you might want to see or something that shows that doesn't have to be with a doctor. So in my vet, it could be they went to the VA hospital, they got a PA to sign off on it, they got an administrator to sign off on it. Cool. They say that we have this. So now they want to bring in, and it needs to be a domesticated animal, not a giraffe, not an alligator. That doesn't count. But if they bring in the potbelly pig, then yes. And you're going to treat it just like the other person. Now, Tiffany Elder, do you think that you can charge a pet deposit on these people because they're bringing in a pig?
I would think so.
Okay, so take a sec before you. It's a quick response, Tiff. Is that potbelly pig a pet? Unmute yourself.
Oh.
Unmute. There you go.
No,
Is it
it's not a pet, but given that there's an animal on site that could do damage, can you? I would hope.
Well, so pause. Think this through now, Tiffany. If it's not considered a pet,
Wow.
and there's damage, if there was damage to a normal apartment with no pets, how would you recoup your loss?
Through a standard security deposit.
Exactly. So that's what you're going to do. So the potbelly pig in this case, let's just say it was a vet that was in there, right, Tiffany? You can't charge a pet deposit on it. But if that pet does damage, it's just like the person doing damage, right? If the potbelly pig is considered the right hand of the person, well, then it's just like the right hand of the person is doing damage to it. So, it would come out of that 2 month, let's say it's a year lease, you have a maximum of 2 months security deposit. It would come out of that security deposit, whichever that you would charge on it. And that can happen at any point in time of the lease, right? Now, stay with me, Tiffany, on this, is that what if now you have a non-aggressive dog policy for your apartment complex, no Dobermans, Rottweilers, German Shepherds. And what if this vet comes up to you and says, yeah, I've got a German Shepherd? Does that change anything? Unmute yourself when you want to chat.
I'm thinking hard about this one. Again, I would hope that that the policy would override, but it sounds like it would not.
The
in this
policy
case.
does not override because
Yeah.
why? Sis?
Pardon me?
Because why? Why don't you think the policy overrides?
If you're saying that it's because it's a service animal,
It's an assistant animal or
oh,
emotional
well, an
support.
assistant animal.
But-
Well,
It's just like the person, right? That's what we got to think of it. And so you got to let that German Shepherd, even though the next door neighbor to him has a 6-month-old baby and is scared of the German Shepherd, they're going to have to get over it. Okay.
question.
Sure.
Question. So for your insurance policy, any insight as to how that would play out?
You're going to have to
Does
talk to your
insurance
insurance
policy-
policy. You're going to have to talk to your insurance policy.
Mhm.
Yes. Yep. And there we go. Just making sure someone's muted on there. So yeah, so you're gonna have to check with your insurance policy on that because you're gonna have to let that dog come in. Now, here's the interesting thing: you can't also, if the neighbor complains to you and says, "Well, that dog nipped at my baby," right? You're gonna have to. You can't just take their word for it. It actually, you or a staff person has got to witness this happen. Okay. Now, of course, if the dog actually does nip at the person, then actually like bites the baby or something or whatever, then of course you've got other actions you've got other proof and stuff like that. But you can't just take another tenant's word for it on the emotional support side of it. Sound good? Good. Yeah. Any questions so far from anyone on this? Yeah. Ruff.
Yeah,
Or Rafe.
so- yeah, however you want to pronounce it is fine. So you said not just dogs. I've seen domesticated pigs in neighborhoods. I think it looks really funny. I think it looks cute. I mean, it's funny, but I know that they're extremely intelligent, and I could see that happening. Are there any other animals besides dogs and pigs that apply? I saw in the chat some people said you can't discriminate against any of these types of animals. I don't know the rules on this. Are there limitations to what types of animals?
Well, so the limitation is domesticated. So anything that you might find in someone else's house, right? And I'd say normal situation, right? You can't is like snakes, birds, cats. I'm trying to think of so it's Amanda just put ferrets, yes, hamsters, those kinds of things would be considered that. So those would be considered domesticated. If you thought it was, exotic, like I was using like an alligator or something like that, then no, that would not apply. And anyone who's kind of writing a letter for them or something like that, it would be able to address that as well, right? I think Dolores Coe, what you said, city ordinances may preclude certain types of animals or personal property rentals. No. Federal law trumps this. A city might say, let's say chickens. Chickens are a domesticated animal. And so even though this, and actually like where I live, we live in Wake County, every municipality there allows for chickens. They cannot preclude that fair housing of the federal government's fair housing on it. Doesn't override. And so when we're getting into fair housing, let's go over a rule, for instance, which is one of it is about laws in general. In that, when the federal government makes a law, right, or on it, it's not a king demanding, this is it. There's going to be some jockeying for positions. There's a reason I'm telling you all this stuff, right? So you got a bunch of people making, figuring stuff out, which also carve out some caveats to it. And so the federal law comes out here. The states can usually make that more restrictive. Okay. They can't usually make it less restrictive on it. Now, when it comes to the fair housing, who oversees fair housing is HUD. And we're going to get into something in just a second. I want to show you here. Let me just, let's see. Bengal tigers. No, Bengal tigers don't count. My oldest had a duck that even went to school with her. There you go. Okay, cool. Now let's pass. I want to go on to the next thing here. I want to talk about with you guys. Hold on, let me get through this. Do you guys remember the acronym Fresh Corn? Just nod your head. You remember that, Fresh Corn? Okay. So we're getting ready. We're going to talk about the 7 protected classes. You see them up on the screen right now. Now, I want to set some ground rules when we get through this and getting through this. I kind of told you about how the laws are done on it. We all kind of know that. We know that there's some jockeying. Rules aren't just, clear cut. There's some things that are carved out, some exemptions and stuff like this. We're going to talk about that. We're going to talk about, and this is important, especially for BICs, because you run a company. You actually run a firm, at least has a firm license on it. Every broker is considered a business in North Carolina, right? Whether you're a sole proprietor, partnership, LLC, you all are running a company that's obviously already designated that. We're going to talk about fair housing from the perspective of risk management to your business. Okay. In order to do that, we need to know definitions and how that applies to the law. We are not interested in social constructs. We're not interested in what your friends say on Facebook. We are going to go by definitions, and we're going to move forward that way and how it relates to your business. And I say that because we're going to go and we're going to try and figure out what do these 7 protected classes mean. Now, why is it so important? Right? Why is it so important that we talk about these 7 protected classes on it? Is because here's the thing. If you're accused, if someone said Steve Henion, Steve Henion, what would they say? Steve Henion discriminated against me because of race. Okay, and they would raise that complaint to what's called the North Carolina Human Relations Commission. Now they might raise it to the Attorney General or the Real Estate Commission, but they don't deal with it. They're going to just funnel it back down to the North Carolina Human Relations Commission. Every state has a bureau like this. And this is really what's important, guys, and why we're talking about it. Is that when a complaint is raised against you for discrimination, you are presumed guilty until proven innocent. Okay? And so 180 degrees from the way our law system works, right? You have to prove your innocence. And so it's a tough bar. And so what we're going to talk about is more of, I'm going to give you some examples. I'm going to give you some pendulum swings to kind of show you some extremes, maybe extremes, and things that have happened to our company and stuff, or things that practices we have employed in our company to kind of give you this picture of how you want to run your business and some of the risks or non-risks you think that there are. I say this in that part of, many of you have heard me say the phrase, it's never a problem until it's a problem. Right. And so you can be like, well, Steve, that's silly talk and whatever I say. Well, fine, until it's actually raised against you and you're now under the microscope of, okay, did you discriminate? And you can't just say the North Carolina, are you kidding me? I love everybody. I'm a rainbow here. I love it. What? That doesn't fly. They're going to want to know exactly how you conduct your business. Why did you do X? Tell us about this. Okay. So in order to do that, one of the first things we got to talk about, one of the very first anti-discrimination we had law that we passed in this country was in 1866. 1866. Jim Burns. Jim, can you talk to me, Jim?
Sure, I can talk to you. What's up?
Awesome, brother. So tell me, Jim, what was happening in 1866?
1866. I want to say that was Civil War time frame or afterwards.
That's right. It was actually the end of the Civil War. That's exactly right. And so let me. I'm going to come back to you, Jim. Go ahead.
For sure. Of course.
Huh?
I said, of course you are.
yeah. I'm going to come back to you. So we're in 1866. Everyone, I want you to write down. I want you to put on the chat what you think the word, here's what happened in 1866. 1866, we said, you cannot discriminate based off of race for any reason or for any reason in any situation across. So from business to housing, you cannot discriminate based off of race. I want you to go ahead in the chat and write down what you think the definition of race is. Really? Nobody's jumping on this one? There we go. Come on, y'all. Amanda can't be the only one out here. What does race mean? I mean, if someone said to you, hey, you discriminate based off of race, you got to know what that means. You got to know what race means. Okay, what if I discriminated against it? What did I do? How is that? We've got a few. No one wants to go. All right, there we go. Linda Taylor, you said nationality. Why'd you say nationality? Are you, Linda, are you there? Okay. Marca Ocasio, you said color. What's up with that?
Back in 1886, they didn't consider national origin or anything if you were anything different than the socialized society, then you were a different race. And it was pretty much based on color.
Well, do you see that what we have up there? Do we have another protected class, right? Do we have another protected class called color? Mm-hmm. So are you saying color and race are redundant?
In 66 and 1866, yes, that's exactly what they meant.
Oh, okay. So
that was the question.
Yeah, yes, but that's not correct though. But I want to ask you, who were we trying to protect in 1866?
Everyone else but the white man.
Everyone else but the white man? So when we said
66,
when we said we can't discriminate, you're saying that we said we can't discriminate. The only people we can discriminate against is the white people?
No, I mean, but it was never really discriminated against before that. Well, there was some, yes.
Well, I can tell you my family heritage started with being
the Irish
over here.
Oh, yeah.
So when we say race, you're saying we carved out white people?
No, I'm.
No. This is good. We're talking about this. We need to talk about this. So let me. Who were you trying to protect? Were the slaves, right? Black slaves at the time, color slaves on there. But and that's one group. But there is a specific definition for race. For race on this, the black slaves, where'd they come from? Right? They came from Africa, right? The black slaves did, right? And so that we talked about on that. The racial term, there are only 5 identified races in the world. 5 races. That's it. And they are identified. And they have a name. And it's based off of physical features of the person. Physical features. And at the time, it was the Negroid that was coming from Africa, and then that actually gets broken down in East and West Africa, but it was the Negroid that was coming from there. We also had folks that were working on the railroad on it, the slaves, and those were the Chinese primarily. Okay, and those are Mongoloids that are there. That's the second one. The Indians are Capoids. Then you have Australioids, which are out of Australia and New Zealand. And then you have Caucasians, also Caucasianoid on it. That's what were the people who were making the laws. Okay, so our first anti-discrimination law went to try to encompass all the races in the world, which are the 5 identified, based off of their physical features. That's really important in the definition. Thanks, Marca, on it. And so that's why it was across the board. There was no like caveat, like this isn't included. It was across the board. it just says you cannot discriminate based off of race whatsoever. Okay. Someone said there's a hand going. Who had a question? Please just shout out if you had a question.
Hi, this is Dina Paul. I just wanted to say that
Hey, Dina.
Hi, good morning, everyone. I was always taught that there were race, I don't know the official definition, but there were only certain races and they were based off people's physical attributes, okay? And they are white, Black, Indian, from India, Asian, and God, there's one more I can't remember. I can't remember the other one, but that's what race is.
So
And,
you're kind of blending a couple of things on it. And so you're right that there's 5 and it's based off of physical characteristics, but the names that you're using are used for other protected classes that we're going to talk about. Like when you say Black, that's going to fall under, we're going to talk about this in a sec. The names that you were using, like Black and Asian, are going to fall under different protected classes that come later. Okay. So hold that thought when we're going through it, guys. It's break time. We'll come back at 10 o'clock or what is 9 o'clock, whatever time it is. Yeah. 10 o'clock. We'll see you at 10 o'clock, guys. So hopefully you've got you've seen on there. I think we almost got everybody. We got a good chunk of folks have seen the poll question, guys. Do you see that poll question? If the settlement of a residential real estate sales transaction takes place on Friday, but the closing attorney is unable to record the deed until Monday, do you have to adjust the prorations? And the answers are either true or false on that. If you can, just take a minute. If you haven't, just before I close it out, if you can just quickly answer that question. Is it true or false? You got to readjust those prorations. Give you about 15 seconds to go ahead and do that. If you have, we got folks. All right, we got some folks signing in, doing that. Excellent. All right, let me end that polling. I'll share the results with you guys. So we've got a 60-40 split. The answer is false. Answer is false on that, guys. So that, and the reason is in the offer to purchase, the 2T, it actually says in there prorations are as of settlement date. So when we're signing on there, it's as of settlement date. So it doesn't matter when it actually, if it closes on that weekend. So false is the answer. Good job, guys. Great on that. So I want to get back. We're getting back to the thing about race. I want to make sure, look, this stuff is not my opinion. This isn't my opinion. I'm telling you what the laws are and how the laws are defined and how that's going to apply to your business out here. And so, again, it's not about social construct. It's not about stuff that we're chatting about and what we think and stuff we're talking about, in Facebook on in 2021. This is the law and how it's applied. And it's actually present today. So the laws that we're talking about, the non-discrimination based off of race is in effect today as a federal law. And they carved out 2 caveats for that. There are 2 caveats that were in there where if you own a place, if you own like a duplex, tri, or a quad, and you live in that unit, you're the owner and you live, and then you want to rent the unit next door. Let's say it's a duplex and you want to rent the unit next door. You are allowed as the owner to discriminate based off of race in who you put into that place next to you. Okay. Is that they carved out, the rationale, at least at the time, was that, hey, even though we want to get everyone getting along together, we're not going to force people to live next to people who they just don't like. Now, you can't advertise discrimination, right? You can't say own a place and say no Caucasians. You can't say that. You can't say no Negroids apply come in there, but you can just simply be, I'm not allowing those people to be there. Also in the law is one that says that it can pass down to an immediate family member. So I could say to my son who lives there, if I own it, my son lives there, I could say, well, we're not going to have, based off of race, we're not going to have Capoids living next door to us. That is on the books today. Okay. Now, if you're selling your place, you can't discriminate at all because you're not going to live there. Okay. So you're getting rid of the place. But if you're living in a duplex, tri, quad, single family, and you want to rent out the basement or something like that, that applies. Those caveats apply. I'm not saying to do it. I'm not saying not to do it. Just saying that's the caveat that's in the law today. I'm on it. So that was in 1866. It wasn't until 1964, so 100 years later, 1964, that we added 4 more. Okay, so it was 100 years later, 64, 66, 68 civil rights acts that were passed. Okay, and so in that, in during that period, this is where we added in color, religion, national origin, and sex. Okay, now I'm going to give you let's talk about color. Color is any color of the skin, however you want to classify the color, yellow, green, white, black, red, whatever color, that's color. That's why it's a separate category that's in here. National origin. Now, national origin. Let me let's see. This is where you're based from, where you were born from. Okay, so let me. There's a reason I'm going to tell you I'm Catholic, but like the Irish Catholics that were coming over were being discriminated based off of because of where they're coming from and also their religion at the time. And let me give you a personal thing. So my father was born in 1912. Okay, 1912. So, he was a senior in high school during the Great Depression in New York City. All my family comes from New York City. I grew up just outside New York City in Connecticut, though. And so I've got one sister who lives in New York City right now. And so when I grew up, right, my father had a name for everybody. There was just a name for everybody. Now, he didn't mean it derogatorily. It was just, that's so-and-so, and that's, oh yeah, they're the blah, blah, and fill in the blank. And before we get all crazy and like, oh my gosh, he should have been locked up in jail. Let's remember, like, I was just up in New York City a year ago, attending a funeral. And, I went to eat in Chinatown, right? I went to eat in Little Italy, right? So my wife is from Milwaukee. In every corner in downtown Milwaukee had a type of Catholic church. You had the Polish Catholics, you had the German Catholics, and they went to that church, right? The Polish didn't mix with the German church. That's why you called it that. So this brings us to national origin, right? So in the 60s, we want to say, well, look, we don't want to discriminate. We don't want to say, hey, we're not going to give any jobs to those Irish, right? Which was literally happening in New York City, right? I mean, as they're coming over on the boats in Ellis Island, they're saying, no, we're not going to hire the Catholics. We're not going to hire the Poles, whatever the name was that they wanted to use. So we said national origin. That is where you originate from. So you can't, but you can't be born in America and then assimilate with your lineage to another country and then say, I'm being discriminated based off a national origin. Okay. Now, not saying that you might not be discriminated for other reasons, but if you were to, like, in a classic example would be African American, right? If you're a Black person who was born in America, you couldn't use national origin as if saying from Africa, the reason they're discriminating against me is national origin because my lineage comes from Africa. Now, I'm not saying you aren't being discriminated against. You just couldn't use it for that purpose. There might be one of the other 7 that you could use that actually would be justified on it. But I'm giving you that example of it because, obviously anyone could then say, because based off of lineage, I mean, I come from many different countries. I mean, my lineage comes from many different countries. Anyone could say then they're being discriminated based off of their national origin. So it's specific to where people, and it was trying to address the people, like I said, that are coming over, right? You would say, you could say people are being discriminated that are coming up from the Mexican border, right? Or they're from Ecuador or whatever. If they're not born here and they're coming over and being discriminated against, that's where the national origin comes in. So let me ask Lisa Chisholm. Lisa, can you hear me, Lisa?
I can.
Okay, so let me ask you a question. Can I do this as a business owner? Can I say I am only going to service English-speaking clients?
No.
Why is that?
because that's discriminatory.
Well, I mean, I discriminate for lots of reasons, right? I mean,
Correct.
so and now I'm bringing this up, right, Lisa, is because, right, I mean, I discriminate based, I won't do a listing for less than 6%. Am I discriminating?
No, that's part of your job.
That's discriminating, right? Why don't you do listings for the 4% people?
If they're
I'm
your friend, you
discriminating.
may do that.
Right. I'm making a
You
decision
adjust
of
every time.
who I'm going to do business with. That's discriminating, right? I mean, that's
I
true.
disagree.
Huh?
I disagree.
Okay, but I mean, it's still a fact. I'm discriminating based off of I have different things I want to do and who I want to do business with. The 7 that you can't discriminate against are the ones that we've got up here, right? And so when I say I will only service English speaking people and you say, no, I can't do that, are you saying then that and I'm trying to get you to think about this. This isn't picking
Well,
on you.
if the person spoke Spanish, for instance, and you did not speak Spanish and they brought a translator with them so you could understand what they were saying, it might, if you had issues with understanding them, then yes, if you couldn't understand them, you could say, hey, I cannot work with you right now because I don't understand you.
Okay, but well, so listen to this too, Lisa, is I'm responsible for that, my client, right? I'm not signing the translator, right? So I'm responsible for the client who doesn't speak English, knowing all the details that I can explain to them. They understand everything to do with the contract, right? They have to understand about the CMA, the pricing, everything. Am I responsible for the way that's being translated?
No, because you have no way of controlling it.
Right. Well, but if there's a problem, who's the real estate commission come to?
You.
Yeah. So now let's go back to the question. Am I required to do business with people like that speak Slovakian?
I would say, I would say, yes, you're required to do it.
Okay. So here's the thing. You're not. English is not language is not a protected class. And you're not required to get a translator. You're not required to communicate with a translator. And so the problem that folks make is that they make this analogy that like, well, language equals national origin. And there's a specific definition. The definition is where you came from. And that's why I was saying that you can discriminate, meaning that's all I will do. I will not service anyone unless they speak English. That's it. I'm just not taking someone who doesn't speak my language. I can't communicate with them. Now that's my choice. That's my business choice. And it's perfectly legal to do that. We get any questions on that? Cindy says, no, there, you'd be doing them a disservice. Yeah, right. Amy says you'd be doing, yes, I would be doing a disservice. Plus I'd also be making myself liable if I screwed up in the translation or anything that happened. Yes. So thank you, Lisa. Thank you very much. Thanks, Lisa, for joining.
You're welcome.
So then we get to, well, let me go into religion. Religion, it's not like your Fab Five. I told you I was Catholic. It's not Catholics, Protestants, Jews, Hindus, and Muslims on it. It's whatever belief the individual has. Okay. And this gets into another gray kind of an area here though, too. And I'm going to give you some examples, even with me personally. So I had, I can't remember when it was, but you guys might remember Tom Cruise, who's used to, I don't know if he still is, but used to be a point person for, Scientology. Okay. And so he was on an Oprah Winfrey couch, jumping up and doing something on Oprah Winfrey shows many years ago. And the next day I had agents in my lobby. They were making jokes about Tom Cruise and they were making jokes about Scientology and stuff. And actually it was pretty funny stuff. It was pretty funny. But after learning all this stuff, what if someone had walked into my office while this was going on who practiced Scientology, right? David Menaker, might those people who practice Scientology feel they might be discriminated against in my office? What do you think, David? Unmute yourself, Dave.
I don't think not being able to take a joke is discriminatory.
Okay. So, hey, pause right there for a second. I'd probably think that, I might be on the same path that you're on. At least I was at that particular time, because it really didn't bother me. I thought it was pretty funny. But here we're talking as business owners. Remember, if that person comes in who does practice, say, Scientology, and hears the jokes and then raises a complaint to the Human Relations Commission, your job is to do what then? Prove your innocence.
Well, you said they just walked in the office. I don't see that that's a business relationship at that time.
Well, it might not ever be a business relationship because they feel like you'd be discriminatory against them.
Well,
right?
That's, like I said, that's their problem.
Well, it becomes your problem, and this is the reason we're talking about it. It becomes your problem when they make the complaint. And this is part of the things that, and I'm not saying don't talk about jokes in this. What we're talking, I'm giving examples.
Okay, well, do me a favor then. Okay. Form the complaint for me.
And what? What do you mean? You mean me?
You say they're just making a joke about Tom Cruise on television the night before, and somebody comes in and raises that to the level of a discrimination complaint. Let me hear the complaint.
Right. The complaint says, I went into Dave Menaker's office and they were saying derogatory and slanderous things towards.
Well, you just went from joking around to derogatory and slander.
No, David, it's not. It was jokes that was happening there. This is what we're talking about. It was jokes that was happening, but it was the interpretation of the person feeling discriminated against. It's not your interpretation; it's their interpretation.
All they were doing was reporting what they'd seen on television.
Well, okay, fine, Dave. Here's the genesis of what we're talking about, and I really don't like after this call, Dave. Like whatever you do is fine with me. But what we're trying to present to you is that you're on the defensive. When that complaint gets through, you don't have any control what that person does in the complaint. All you guys now answer it, right? And if the North Carolina Human Relations Commission comes in, because all of our agencies in North Carolina talk, then the North Carolina Real Estate Commission comes in. Now you're answering to two different agencies regarding whether you are discriminatory. I'm just trying to have you avoid that situation. You want to have your if you want to have your jokes, that's up to you.
Yeah.
On it. But you know what, Dave? Stay with it.
May I say something?
On this, Elisa, I'm sorry. Go ahead, Elisa.
From a legal standpoint, he does have a point. From a legal standpoint, from an ethical standpoint, and in a business standpoint, then you have a point. So you're both right.
Well, yes. Let me because I just don't want to share all the rightness here. Is that what the thing is, Lisa? And thanks for bringing that up. But it isn't about legal and ethical on it. What we're raising on it, and I'm not saying that David in objecting might not win overall. The point is whether you want to avoid unnecessary risk. Right. So let me give you an example. The sign of the fish, right? If you all know the sign of the fish, right? It represents Christianity, right? Now, I'm not telling anyone to take the sign of the fish off their car. I don't have it on my car for a particular reason, because, and I'm just going to share it to you, is that, if you pull up to show something to a person and they pull up behind you and they see the sign of the fish on the back of your car, might they feel you're partial to Christians? And the answer is yes, they might feel that way. So then a complaint gets raised about it, that like all he's doing is he is partial to Christians on it. Now you're like, Steve, that's crazy talk. It isn't when a complaint is raised against you on this. But again, I'm not telling you what you're supposed to do. I will tell you, here's an example that was used in MLS. In MLS, my son, our youngest son, goes to St. Raphael's Catholic School here in Raleigh. And I don't know, we've got people from all over here, but it's on a major corridor in Raleigh, right? So on Falls of the Neuse Road, it's a north-south corridor on there. If you live in North Raleigh, you pretty much know where this is, okay? So the question is, can I say in MLS, take a left at St. Raphael's Catholic School? Tiffany, what do you think? Tiffany Elder. You said yes?
I would, if you're looking at it as a landmark.
So here's the thing. And this is actually an example that was used with our training in the Real Estate Commission, is they would say, no, because it is a landmark, but it's what kind of a landmark?
Religious
Landmark, right? And so, and people could say, well, wait a second. I think Steve's steering people who are Catholic to that particular area, or the opposite. Steve's steering people who aren't Catholic, knowing that they shouldn't be in that particular area if they're not Catholic. And the North Carolina Human Relations Commission person said to us, our first question on a complaint is going to be, why didn't you just use the name of the street, Bland? And so now you're on the defense. This is just the reality of running the business, guys. I mean, I'm not saying don't do it and do what you want to do in MLS, but this is the thing you're facing with potential complaints on discrimination. You go to sex. Sex is male or female. Now, this is an important change. Sex is male and female. Now, the Association of Realtors made it several years ago. They said realtors cannot discriminate based off sexual orientation or gender identity, and they put that into the ethics, right? So as a realtor, you couldn't discriminate based off of sexual orientation or gender identity, but non-realtors could, because it's not a law. Okay, non-realtors in the general public could discriminate based off of that, right? A seller of a home could say, "I'm not going to sell to that gay couple." Yeah, and it was perfectly legal. So it was only for realtors. In January, the Supreme Court made a decision regarding employment, and they said that sexual orientation and gender identity are protected in the employment structure, right? EEOC and all like that. Said those two we are saying that is part of an employment's protected class. They didn't make new classes up. They didn't make new laws. They applied it to being protected under employment. On March 1st, HUD then made a decision and said, because of that Supreme Court ruling, gender identity and sexual orientation are protected under the category of sex. Okay. So while sex is identified in the law as male and female, HUD for housing purposes applied sexual orientation and gender identity. So today, because this hasn't been challenged in court, right? Because it's applications, it's a unelected body that's made this application. But for us and what we do in our license and what the citizens of North Carolina, we cannot discriminate. No one can discriminate based off of sexual orientation or gender identity under that basis, because HUD made it and put it under sex. And that also goes for any homeowners who want to sell their property as well. They can't discriminate based off of sex, sexual orientation, gender identity. Are there any questions on that regarding the sex part in those two added categories? Because there are other states that actually added those as protected classes, like California added sexual orientation and gender identity as numbers 8 and 9 as protected. Okay. So this would not be, this information is not going to be in your textbook because it came out since your textbook was printed. Your textbook was designed in July of last year, so it's not in that. Marco, what's your question?
You had used Tom Cruise as an analogy in Scientology and everything, and just the way he acted, and I was taking it literal. If Tom Cruise walked into my office and wanted to hire me, I would say no. And if he pulled up something that says, hey, you're discriminating me because I'm a Scientologist, even if I was talking about what a right in as he was walking in about what an idiot he is, or even making Scientology analogies or jokes, I could just going to the commission. If he did, I would be like, look, I didn't want to work with him, not because he's a Scientologist, but because he's an idiot, and idiocy is not protected in under even handicap because it's not in the DSM. I mean,
well, true. There's and you bring up you reference actually what there's a term called quiet discrimination, right? And that you're right, of course, idiocy and all that kind of stuff is, you could just say, I just didn't like the guy, right? The quiet discrimination is where people are discriminating and then they use other reasons to discriminate. Like there are people, right, Mark? And I'm not saying this is what you're talking about, but there are people and we did this. We talked about this a couple of years ago, guys. One of the most discriminated classes is it's been surpassed, but the number one discriminated class a few years ago were Hispanics, and they were discriminated against in renting of homes because owners didn't want to rent. They had this they had this belief that with Hispanics comes a lot of people. Okay. And so they didn't want to rent to them. So they would just say, they would use this thing called, well, I only have 3 bedrooms. That's only 6 people. You have 8 in your family. So I can discriminate against you and say, no, I'm using that because of it's too many people for the house. And HUD came in and said, you can't do that. Maybe you can do that if in case you had a septic system that was based off of that, the 2 bedrooms. But if you're in a city water and sewer system, that isn't an excuse that you can use to do that. There might be a bonus room that you could sleep 6 people in. There might be a full basement on it. This isn't, so this is where we were talking about quiet discrimination stuff on it, Marco. But thank you for bringing that up. All right, 2 other things. Let's talk about handicap. I just want to talk about one thing. We already talked about handicap. On this is what's it called? A reasonable accommodation. It's a term called reasonable accommodation. And so if Lane Benton, if you own an apartment complex, right? Mm-hmm. And I'm in a wheelchair, right? And I'm renting from you. I have an apartment on the first floor that's a handicap apartment. And I come to you and I say, hey, Lane, listen, man, I love the place. I love the apartment that I'm in, but I'm in this wheelchair. I work second shift. And by the time I get home, I got to park like 100 yards away because, everyone else is home. Can you do me a favor, Lane? Can you just mark a space in front of my unit as mine? Make it handicap. You can even put Steve Henion on it, but make it so it's my unit there. Could you do me that? Would you be obligated to have to do that? Obligated meaning the law saying, yeah, Lane, that's a reasonable accommodation.
I don't think you're required to have to make modifications to the property to equip someone to be able to, for it to be their, use. You may be required if they want to do that on their own, you might be required to allow them to do that. And that, I'm not sure exactly where we stand on that, but I don't think you're required to have to spend money to accommodate a certain person.
Okay. So in this particular case, you would be required.
Okay.
And it falls under, and I hear where you're going. We're getting ready to get to your reasoning is that as a reasonable accommodation, this would be, you're not losing a parking space. It's costing you minimal amount of money, maybe to put a sign on there. They're saying, HUD would say, yes, Lane, you need to do that. Okay. Now, an unreasonable, and right, there's no you can't go look it up and say, what are all the things that are reasonable accommodations, right? It's the floating scale. But I'd go to the other side of the spectrum and I would say an unreasonable would be like if I came to you as a new renter and all your required handicap rooms are occupied, right? You got tenants and all. And then I come and go, Lane, hey, I really like your place, but I know you got a first floor, make it handicap. Mm-hmm. You wouldn't have to do that.
Right. Okay.
In fact, what you could do is say, hey, Steve, that I'm willing to do it, but it's going to cost 20 grand to upfit it the way you want it. So I need the 20 grand up front and I need 20 grand put into a deposit account so that I can retrofit it back. Does that make sense?
Yes.
Perfect. Awesome. So that's it on the handicap. Now, a little note regarding handicap ramps. You can charge the tenant to install a handicap ramp, but you cannot charge them to take it down. HUD has determined that a handicap ramp is an improvement to a property on it. So it's there. So you can charge them to put it up. You just can't charge them to take it down. All right, let's go to the last one, which is a familial status on this. So familial status is what? Dolores Coe, what's familial status?
Whether you're married or not?
No.
Or what your family is compromised of?
Okay, compromised of. Now it's specific, meaning like what?
children, aunts, uncles.
Okay, so let's stop with children. It's children under the age of 18. Okay, and that includes the woman pregnant, right? So an unborn child is also protected under that. So what it's saying is you can't discriminate off of familial status, off of people with children under the age of 18.
Can I
Can't-
ask a question?
Sure.
Getting back to the number of people in a house, I made a comment that it's my understanding when you're renting a place, you have to have so many bedrooms, like if you have children, so that you can separate the boys from the girls, so that the mother and father aren't sleeping in the same room with the children. That's always been my understanding.
I'm confused on the question. Are you? I don't understand the question. So maybe.
Well, I guess your statement is that you can't discriminate based on the number of people in a house.
Well, so there's okay. So let me explain that. Let me explain it. So, HUD had said, right, if you are on like a septic and well system, right, that system was built based off of two, at least in North Carolina, off of 2 people per bedroom. Okay, so you can discriminate if you're on that particular system, 2 people per bedroom. So if you got a 3-bedroom, you can limit it to the amount of 6 people living there. Okay. However, if you're in Raleigh, and this is actually a case that was in Raleigh, if you have a 3,500 square foot 3-bedroom with a bonus and a little bit of a walkout basement, you can't use that. It's actually, HUD has said it's on an individual basis. You can't use the excuse if it's on city water and septic. You can't use the excuse 2 people per bedroom. So the HUD said, look, if you can put people in, if you got a 400 square foot bonus room and 4 people can sleep in there, then 4 people can sleep in there. If you got a walkout basement and you can put another 4 people down there, that's 4 people down there.
Wow. I mean, that's not what I've been told. And DSS gets involved with stuff like that too.
Well, this is housing. So this isn't, I'm giving you the theory behind that.
I mean, I've had experiences where DSS has come out and said, no, they can't rent this because it's only 2-bedroom and the mother and father have 3 children, 2 boys and a girl, and they can't all sleep in the same room.
Okay, well, all right. I mean, I'm not making the comment as far as what DH.
Yeah, I'm just curious if it's changed or.
No, I'm giving you the housing rule as far as HUD goes.
Okay.
So, Dina, do you have a question, Dina? No. Oh, I'm sorry. I saw you waving. So familial status. Can I discriminate against an unmarried? If I have a 1-bedroom apartment, can I say to the unmarried husband, unmarried male and female, can I refuse to rent to them? Dolores?
No.
Why?
Because you can't discriminate against familial status.
Well, familial status doesn't protect marriage, doesn't protect single, doesn't protect your marital status.
Well, let's put it this way. I wouldn't go down that path.
Okay, but the question is, can I do it?
I don't think you can.
Well, okay, so you can. Marriage is not a protected class.
Right.
And in fact, there's actually a law still in the books that says it's against the law to rent a single bedroom to an unmarried male and female on there. In fact, it was challenging a small court and a district court where you had a sheriff who was fired for living with her boyfriend on it. And then she took that to court, won in district court, but the law was never changed on it. So that law stands today. And actually, there are apartment complexes that will refuse to do that. And it's interesting. Well, it's not a protected class, and not part of familial status. Wouldn't that Amanda? What do you say? Wouldn't that fall under religion? It's not. Being married isn't religious. Being unmarried isn't religious either. If that's what you were saying, I don't know if you meant something else, Amanda. Amanda, did you want to say something? Nope. Okay. Yes. Oh, Rafe, you had a question?
What I was trying to say, sorry. So not all religions would recognize marriage. So we're forcing couples to get married to be able to rent properties. That doesn't.
No,
make sense.
marriage has nothing to do with familial status. That's what it is. Meaning you can discriminate against people if you want to, based off of their.
But I'm asking, wouldn't that end up falling under the religious bubble? I guess.
No, I just don't. No, like so. I'll just be the antagonist in it, and that I would just say no. I'm just not going to rent to people who aren't married.
Okay.
Yeah, I mean, no different than you could say kind of like what Marco was saying. I don't rent to people who have red hair. I mean, you right, and so it kind of falls under that line. And I'm not saying these are practices you want to employ. It's just saying that could you do that, and that would be the answer on it. Rafe, you had a question, Rafe?
Yeah. So with regards to sales, we've been talking about rentals. With regards to sales, we know that that there are neighborhoods that are 55 and over. So obviously, I think at least one of the couple has to be, or somebody has to be 55, right? But with regards to this familial status, I understand that you're saying it has to do with couples with children that are younger than 18 years old. But what about discrimination to people? You know how a lot of times happens in practice where we can't tell our clients, our buyer clients, they want to know, are there a lot of kids in the neighborhood, right? And we can't tell them if there are kids in the neighborhood or if there aren't any kids in the neighborhood because of familial status.
Oh, no. Just let me, but go ahead.
No, I agree, please.
Okay. So let me address a couple things, because I hadn't tied the loop on familial status. I see a couple questions, or someone came in, Marco was talking about senior communities. And yes, so in familial status, they carved out a couple of niches, right? So during this, and remember, the handicap and familial status came into being in 1986, right? So you have 1866, 1966, 1986 when these seven got employed, right? So familial status, they carved out, and at first it was 65 and older group can have no children at all. And then it became 55 plus, which could then have a section up to like 20% could have children in it and still comply with the rules for those different age brackets, right? And then what you were talking about is like, we shouldn't be asking about families and stuff like that. That's actually governed by your license, right? So the North Carolina Real Estate Commission says that you can't, so that you don't fall into the trap of going and discriminating against familial status. Does that make sense?
Mm-hmm.
So by virtue of your license, you could do that. Like, it's not against the law for buyers to go, I want to look for a place that have kids, right? They're not discriminating. They can go and do that, right? But by virtue of your license, you couldn't sell it based off of, I'm going to find you can't even search, right? You can't search for a neighborhood that has children under the age of 18, right? You can't search for Catholic neighborhoods, right? And so that's all by virtue of your license, so that you're almost protected from actually getting yourself in trouble in discriminating.
Got it. Understood. So you're saying that, I was under the understanding that, when people ask me, I didn't realize it was because of the license, not because of familial status. But anyway, I mean, obviously I never shared any of that, but I always said, I can't share it because of familial status. I basically can't, because someone.
Well, that's a fair enough thing to say. That's fair enough.
You know what I mean?
Yeah.
In other words, if someone, because, someone could, who is older, right? Let's say an older couple in their, whatever age, empty nesters, they want, the kids are grown, they want to downsize. And all of a sudden they know that their neighbors are also older, let's say, and they want to do the favor to the neighbors and not sell the house to a family that has little kids. That could be one way of discriminating against that family, obviously. So, or vice versa, if it's a young family that says, no, I don't want to sell this to an older couple, I want someone with kids here, so obviously we don't talk about that, but you're saying that it's more so because of the license.
Well, no. I mean, it's preventing the discrimination based off of, right? So there are guidelines and there's rules in your license to try and keep you from MLS has the rules, right? You can't go in there and say this is a Catholic neighborhood. Because they want to prevent the opportunity for discrimination on there, right? And so that it kind of goes to that term that I was using of quiet discrimination, right? You can have a neighbor that says, hey, to a seller, say, I'll look out for all the people that are coming into the house and tell you which ones are families, right? And that's quietly discriminating against, right? But it's one of the reasons why you've probably recently received where these letters that buyers write to sellers, right, saying like, please accept my offer, that don't include pictures on there, don't talk about your family. They've actually discouraged, right? Both the Real Estate Commission and NAR has kind of discouraged the use of employing that, right? Because they don't want a picture of, say, a white family going to a seller of a white family and they going, well, I'd rather choose that family based off of who they represent. Does that right? So it's all ways of trying to protect it. So you're not guilty of the discrimination by fostering those kinds of actions. Does that make sense? Cool. All right. So let me just catch up on some of those things. Elisa, you had a question. What happens if a BIC owns a property not under the company? They have to abide by fresh corn. Elisa, tell me a little bit about what you mean by your question on here.
Well, the question would be if they are a BIC and they own property, right? I felt that they were discriminating against their tenants, but their excuse was, well, I own the property, therefore I do not have to abide by, the pre-established guidelines, the federal guidelines.
No, everyone has to apply by it. They have to do it as an owner of a property. Right. So you're asking if a FSBO, right? They own their own place. They're like, hey, I don't have to abide by.
No. This was a professional, a licensed professional.
Oh, well, no matter what, if you're renting a place, whether you're a licensed professional or not, if you own a place and you're renting it, you have to abide by these guidelines. Yeah, these guidelines, right? Because that licensed professional, like, it's not like a get out of free jail card, right? They have to.
The excuse.
Go ahead.
The excuse was, it is my own property, therefore I have the right to do what I want because I own the property. It is not under a company name, and I have the right to do as I choose.
Yeah, you can't do that. Nope. The law applies to them. Yep. Did I answer? Yep.
Yep.
Cool. My rentals are one reason I became a BIC. They would be. Let me see. Do they live? I'm trying to make sure I got Dolores Coe. You said the BIC is walking down a slippery road. I own a rental. Where are you getting at on that, Dolores?
I just feel that they're held to a higher standard and that the laws apply to everyone when they're renting property, whether you're a BIC or a real estate agent or not.
That's correct. That's correct. And that's right, Dolores. And if you're a licensee, you're actually held to a higher standard because your license makes you have to, disclose certain things like you own the property, you're a licensee.
Correct.
Stuff too. Yep. Good point. All right, guys, let's make sure. Are there any other questions regarding fair housing or anything like that? If it is, just shout out before we enter into contracts. All right, fantastic. Let's okay, here we go. Listen, here comes the vignette coming up.
Mark, a buyer's agent, submits an offer on behalf of his clients for $27,000. The listing agent reviews the offer with his seller. The seller marks out $27,000, writes in $37,000, and initials the change and signs all of the papers.
All right, so we've got someone that's initial change and signed it. Question is, was a contract created? Just go ahead and type in yes or no. Well, we got like 100% on this. All right, well, that's because we're dealing with BICs. You guys are awesome on that. Absolutely. It was just and you guys, some of you put in there, no, a counter offer. You're which that's exactly right. And it hasn't even presented as a counter offer yet too, but you're right. It's not a contract. All right, let's listen to the second one here.
May, a buyer's agent with ABC Realty, submits an offer on behalf of her buyer client to Tammy, a seller's agent with XYZ Realty. The offer includes a $1,000 due diligence fee and a $2,000 initial earnest money deposit. Tammy presents the offer to her seller client, and the seller signs the offer as is without making any changes. Tammy calls May to let her know the seller has signed the contract. Tammy reminds May that the DDF and EMD checks must be delivered to Tammy's office by the end of the day.
Okay, so there's a scenario, and the question on this one is, are the parties under contract? Yes or no? All right, we got a bunch of yeses out of the box. All right, Nigel Terry. Hey, Nigel, good to see you back here. Nigel, tell us, why did you say yes? When did it become a contract?
I believe it became a contract when it was communicated back that it had been accepted.
Bam, dude. Thank you. Good job. Absolutely right. It's when they got communicated. So what are the acceptable forms of communication, Nigel?
Email, written, verbal.
Text? What about text?
Text, yeah.
Yep. What about some of the folks out there might still have a 1,200-pound fax machine. Does that still work?
Probably doesn't work, but it's legal.
Right. Okay. Right. Good job. Right. So those are now. Let me ask you a question real quick, Nigel. Before we go on break, if you're the listing agent and you receive 4 offers, can your seller sign all 4 offers?
No, I don't think they can.
Now, why do you say that?
Because they've now gone under contract before. Well, they can probably sign them as long as you don't deliver them.
That's where I was getting. Nigel, you thought that through, man. That's exactly right. So they can sign all 4, right? Because what's the term that we use, Nigel? I'm just trying to draw it out of you. What's the term we use for signing? You remember? Begins with an A. It's acceptance, right? It's acceptance,
yeah.
acceptance, right? So they can accept all 4 offers, but it doesn't become a contract until we do what? The D word. Deliver it, right? So good. I wanted to make sure that we got that that clear out there, because guys, yesterday we're teaching 100 agents, brokers, and we have folks that were coming on here talking about how they're submitting 3 and 4 offers on different houses at the exact same time. We're gonna bring that up when we come back from break. All right, guys, we're back. We're halfway done. So thanks for making it, keeping it lively and moving things through here, guys. So we got a poll that's up there. It looks like, let me see how many. We've got about 30. Almost everybody has worked on it, I guess. If you haven't, please take the next 10, 15 seconds just to go ahead and complete the poll on it, and then I'll share the results. So the question here is about a refrigerator. If it was working at the time that the offer to purchase was made or the contract, and then it's closing and it's not working, can the buyer refuse to close on that? And let me show you guys. We got a couple of extras jumping in there. Let me show you the results. So the correct answer to may the buyer refuse to close is true. Yes, at the time of the offer to purchase, all items that were agreed upon at that in working order need to be in working order in order to close. So the answer is true for that. So great, guys, for dealing with that. I appreciate it very much. Thanks for doing that. All right, so let's get back to contracts. So we've got it seems to be, having done this, several thousand folks teaching this across the state, it seems like most places are experiencing high, low inventory with higher buyer pool, and we've got a lot of contract offers being made out there. And due diligences, the use of due diligence out there. And in fact, let's say I see something like Linda. I see a couple of comments about due diligence out there. It says Linda Taylor. Linda, you said, I guess this was in response to the previous thing. What the previous vignette? What do you mean not until due diligence is delivered? What do you mean by that, Linda? Linda Taylor. Well, let me ask. Let me go on to. It looks like Morgan. Morgan, you had said yes to due diligence, earnest money. If due diligence, earnest money are delivered. What do you mean by that?
I mean, if they never deliver it, then there's no contract. I mean, if it's you have a contract when it's signed, but if it's not followed through on and not delivered, then it'll be void.
Hold tight on the use of the words that you threw out there. So when does it become a contract?
When it's communicated after it's signed.
Okay. So we have a contract, right?
Mm-hmm.
Is the due diligence and earnest money required in a contract?
No.
Okay. So it's not required. So if the due diligence, so in the contract, it says, when does it say due diligence needs to be delivered?
With the contract.
At acceptance, right? At acceptance.
Mm-hmm.
So let me give you a scenario to you, Morgan. If I'm representing a buyer, you're a listing agent, okay? And we've got the signed contract. I've emailed you the contract and everything, and I said, hey, let's see, for argument's sake, let's just say it's a Friday, okay? And I bring you, I say I'm going to bring you the due diligence check tomorrow, Saturday morning. You with me so far?
Yes.
Okay. And Saturday morning comes and you don't get the check. And then Saturday afternoon, you call me and I said, yeah, you know what, Morgan, I'm going to be there Saturday afternoon. I'm not there. It's Saturday night now. You still don't have it. Do we still have a contract?
Yes.
Okay. So does the receipt of due diligence mean you have a contract or not?
You do have a contract, but then at what point, if it's not delivered, does it become breach of contract?
Oh, okay. So now that there's a better term that you're using on there. So we still have a contract, right? Now, in order for there to be a breach, right? Because you're due the due diligence. The seller is due the due diligence, correct?
Right.
Right. Okay. So the seller's due is owed the due diligence. And this is important that the buyer is not in breach until the listing or the seller via the listing agent does an action. Like the listing agent actually has to perform an action in order for a breach to happen, which means the listing agent has to notify in writing you have one banking day to deliver the due diligence or you're in breach of contract. Okay. So that action has to take place, Morgan, and that opportunity and notice has to be given to the buyer's agent in order for there to be a potential breach. Okay.
Okay.
Right. And it has one banking day. So if you delivered to me on Saturday evening, that letter, I still got to the end of Monday afternoon, assuming it's a banking day, not a holiday. I got to the end of Monday afternoon to get you that money.
Okay.
All right. So that's number one. That's the important part on that. Now with due diligence, now, Morgan, if I was writing up, let's say in that scenario, I have a contract with you, and let's just say it's a $10,000 due diligence check. Have you heard of such a thing?
Oh yeah. Mm-hmm.
Yeah, I haven't written up a contract in the last 6 months less than $5,000, and we wrote one up a week ago with a $20,000 due diligence. We've had people on here saying that they've had a $425,000 due diligence check, the purchase price for the property, the offer price, and it still got rejected. Right? So it's, yeah, I see it, Tiffany. Tiffany, that's right. Yep, they went with a higher offer. So according to the story that goes, so $10,000. Do you expect me to deliver that, or what was your protocol for the delivery of the due diligence?
The buyer agent should always deliver it.
To who?
In my opinion, to the listing agent.
Why?
Just so we know we have it in hand, and then we can give it to the seller.
So why, and I know this is a question you're going to get, there's a reason I'm asking it. So are you or me as agents, are we involved in this contract at all?
No.
Okay. So we're only facilitators, right?
Right.
So I'm going to ask you again, why do you and me need to be involved in the transfer of the due diligence?
I guess we don't. It's just a control thing that I like.
Well, that's where we were going, Morgan.
Right.
And I'm going to put out to you that we need to shed that control, because what's the goal? If you're the listing agent, you want that seller to get that money in their hands as soon as possible, right?
Right.
Because I've had, and we actually have students who have talked about this. I've had it where we've had agents where the buyer cancels the check or before ever delivering it, right?
Right.
And so we want to get the money in their hands. And so why are we going to insert ourselves because we want some paperwork done, right?
Right.
Let me ask you a question. If my client can you you Venmo money?
Yes.
Yeah, right. You can Venmo up to $6,999, I think is the last time I checked. You can PayPal people. Can you wire money? Yeah, right. So if it's $10,000, and all of those have a receipt.
Right.
Right. So what we want to do is say, hey, my seller prefers you to go ahead and wire the money to their account. Here's their account information, or go ahead and Venmo me the Venmo my seller the $5,000. And then you can get your paperwork, because remember, page 15, which is the signing of everything, that's not part of the actual contract, right?
Right.
That's an additional form. It actually says not part of the contract at the very bottom. So that's just a form that we want to have signed for verification purposes, and your BIC wants it and all like that. And you can get that, but we want to get the money to them. Now, there are times where you would get involved. I mean, maybe, Morgan, your clients are on a cruise, unable to get back, and they say, Morgan, can you get the check and just hold on to it?
Right.
Right. All right. So let me give you that scenario too, and how you're going to react. So let's say I've got a $5,000 due diligence check and a $5,000 earnest money check. So far, so good?
Right.
Okay. The earnest money check's made out to you. Due diligence check is made out to your seller. And I show up at your office, Morgan, and I bring you both a due diligence and earnest money check. I actually, I'm old school, man. I actually bring you a copy of the contract, over there with you. And, we have some pleasantries. And I say, Morgan, it's nice to work with you. I go out in the parking lot and I get a phone call from my client. My client says, Morgan, Steve, I had a dream. I shouldn't buy this house. What do I tell him, Morgan? Go back and have another dream. Right?
Yes, no problem.
And he comes back, says, okay, Steve, seriously, I need to I don't want this house. So 15 minutes has gone by. I come in and he goes, I don't want this house. Go back in there into that office and get my checks back. You with me on that?
Yeah.
I come in there, Morgan, and I go, hey, Morgan, this is a crazy COVID time we're living in. But I didn't want the house, and I need to get that earnest money and due diligence check back from you. What do you do?
Give it back.
You give it back. Is that right?
Yeah.
Hold on. I see Amanda shaking her head violently. Amanda, why do you say no?
Well, you have to talk to the seller, I guess.
Well, hold on,
Yeah,
Morgan. Hold on. Just a
you would
second.
need permission from your seller to return that. Now,
Why
if
do I
the
need permission
buyer
from the seller?
agent still had the checks, they could definitely not deliver them on the advice of their client, but we have to do what's best for our client, and we would be representing the seller. So I'm not giving that check back without everybody's permission and an attorney telling me to give it back.
All right. Well, you're going to change your mind after we talk.
Oh gosh.
Yep. Because Morgan's right. He's going to have to give the checks back. Now, he's going to have to give one check back. The earnest money check, I said in my example, is made out to his company. He's required by law with deposit funds. It's made out to his company. He's a representative of his company. They're in possession of it. 3 banking days, he's got to deposit that into his account. Okay, that's the law on the earnest money. On the due diligence side, though, the seller doesn't have the check. He's got the check. Okay. He's just a facilitator. Real estate commission says, give that check back. Give the check back to the buyer, to me in this particular case. Now, that's not saying, Amanda, that the seller isn't entitled to the monies, right? Because it's actually under contract and you got the due diligence. But the seller is going to have to work that out in court or however other way they're going to do it. Us as facilitators are not getting in the middle of this. Does that make sense, Amanda? And so now also, if the earnest money check was made out to say an attorney, let's say Morgan's like, hey, we want to, we have an attorney that's across the hall. Morgan's in 123A Main Street. The attorney's in 123B Main Street. If that check was made out to that attorney and not Morgan's company, Morgan would have to turn that earnest money check back over to me as well. So the difference being, if it's made out to Morgan's company, he's got it. Law says you got to deposit it. Now, if Morgan had put that into the mail, then he doesn't have it. But if he's got it, he's got to give it back then. Okay. And are there any questions? Todd Smith, we should not act as a courier. That's correct. That's great. Hold it. Let's see, Amanda, hold on, Amanda. Maybe you said during COVID, when the seller's been out of town, I've had the buyers overnight the due diligence check to the sellers, but send a picture of the check to the buying agent. Okay. That's cool too. Cool. Let's see. Roxanne says buyer has 1 banking day after written notice to deliver, or seller can terminate. That's correct. Just making sure I'm caught up on that. Okay, perfect. Any questions on that little bit about the due diligence on stuff? So in fact, let me just see if I have a poll question here. Let me just hold on. Hopefully you should all get this. Go ahead and see that poll question. That should be an easy gimme there. I am failing at instructing today. I apologize. All right, let me end this poll. Let me show you guys the results here. So we're split right down the middle on this, where I thought it was going to be 100%. Okay. So all right, y'all, I'm just going to give you, I suck today. So to help ensure that due diligence fee is timely paid, it is a smart idea for a listing agent to refuse to deliver the signed contract until the buyer pays a due diligence fee. Let's see. Let me ask someone here because I don't know. Tierra Belazar, what did you say on that one? True or false?
I put true.
False.
No, I put false. I'm sorry. I put false.
You put false. Okay, because why?
Yeah. I put false because it became once the seller signed, it then became a contract, and then that's when the fees were delivered. Then that's when the fees would be required to be delivered once a contract was consummated.
Right. So okay. So it says here. So the listing agent, but it says it is a smart idea for the listing agent to refuse to deliver the signed contract until the buyers pay the due diligence fee. So you're saying it's okay to deliver the contract because the due diligence fee might not come to you or might go to someone else or whatever, right?
I feel like the buyer should have a contract before going ahead and submitting a fee.
Right. So, but this is the listing agent. So you're the listing agent. I just wanted to clarify.
Okay, maybe I read into it wrong. I apologize. So
no, I'm not saying you did at all. You actually got the answer correct. Okay. So all those who said false got the answer correct. And the reason is you have a contract. Remember, you're just a facilitator. You got the contract. You deliver the contract. You don't get to say whether you're going to hold on to a contract until due diligence is delivered. That's not your call, right? If a contract is a contract, you get it and you forward it on to your client. Then, right, if you want to go ahead and then write that letter that says and email it to him saying you got 1 day, banking day to deliver it. Remember, you got 1 banking day to deliver it, right? So if that contract is consummated Friday night, You have an obligation to your license to send that contract immediately to your client. Period. And if you're, at least if you're in the Raleigh MLS, you've got within 24 hours to make that known as under contract. You can't hold on to the status of the MLS hostage until the due diligence is delivered either. So Thierry, you're absolutely right. You got it right. All the 50% that said false, got it right. The 50% that said true, I apologize for not being able to communicate it properly to you guys. That is going to be on me. Amy Hoyt, what do you mean I disagree? What do you disagree with, Amy?
I'm just a listing agent, and I've been burned in the past where I've sent the signed contract back, changed it to pending in MLS, and then the buyer says, oh, we changed our mind. And I was always taught that if the due diligence fee had not been delivered to the listing agent, that due diligence is not due.
What do you mean not due?
So seller and buyer sign the offer to purchase.
Right.
Due diligence has not been delivered yet.
Right.
And the listing agent. So the buyer's agent has not brought the check to the listing agent.
Right.
At that point, the buyers can say, we rescind our offer. Therefore,
No, there's no. It's a contract. There's no offer. It's become a contract.
Well, we rescind. We've changed our mind, and therefore, because due diligence has not been delivered to at least the listing agent,
that's false.
Due diligence is not due.
Yeah, it's false. Yeah, it's completely wrong.
I
Whoever
wonder-
taught you didn't take this BICUP class. Yeah, it's completely wrong. It's a contract as soon as it becomes a contract. Once it's accepted and delivered, it's a contract. Boom, and you're required by law to go ahead and deliver that off by your license to go ahead and deliver that off to the person. It doesn't matter. Again, it goes back to the due diligence part. It doesn't matter whether you get it. In fact, I don't even have to send, my client doesn't even have to send it to you. They could put a check in the mail directly to the seller, right?
No, I understand, but what I'm saying is, if the due diligence check isn't even in the mail, it hasn't been
Yeah,
delivered.
but so Amy, listen. I'm in Raleigh. I don't know where you are, Amy, but in Raleigh, I've gotten closing checks 3 weeks later, passed across town, right in the post office. So let's just play this out. If my client sticks it in the mail today to your client, right, and it's whatever what is it today? Tuesday, and it's Thursday, it still hadn't gone to your seller. Are we not under contract?
Yes, because they put it in the mail. I guess my question is, if everyone has signed the offer, but the DD check has gone nowhere, and the buyers just say, we changed our mind, we don't want to buy this house.
Yeah, that's
Can
fine. They
you
still
still
owe the due
make
diligence.
them-
They
can you
still
still-
owe the due. I'm sorry. I'm sorry to interrupt. Go ahead, say it. I'm sorry.
So you can still make them deliver the DD?
Yeah, that's part of the contingency of the contract. Yeah. Yeah,
Okay.
a buyer can't, once you're under contract, it's not a unilateral contract. A buyer cannot say, I'm out of a deal. They can't do it. It has to be both a buyer and a seller. They both have to agree to be out of that deal. Once you're under contract, and you have obligations under that contract. You have obligations to deliver that due diligence. Now, if you're in breach, meaning like that's kind of what Morgan was saying, if you're in breach and you don't deliver it, well, then the seller has recourse by suing, right? And so that's the reason why we have all these. And another reason why I'm saying agents should not necessarily get themselves in the middle of the transfer of funds, right? Because as a listing, for me as a listing agent, I want that money in the seller's hands immediately. So we're going to say, hey, we're going to set up, here's how you're going to wire the money, right? And I have done Venmo, have done PayPal, where it goes directly to the client there. Boom, it's done, it's over with, right? And there's no such thing as this made up thing like, oh, we don't have a contract, or I get to rescind them. That's just made up. That's just made up BS. That's all that is.
That's what I learned at Superior. So that's interesting.
Well, you didn't have to call them out, but I mean, that's fair enough. That's an advertisement for me. Go ahead and tell all your folks to come on over our way. But does it make sense at least, right? I mean, because there's other contingencies that are in that contract that need to be fulfilled. None of it disagrees with the fact that let me go over another contract with you. Let's talk about a listing agreement, right, Amy? You have a listing agreement on the sale of the house. Can the seller say at closing, can the seller say to the closing attorney, don't pay commissions? And does the attorney have to obey that law, that order?
No,
Why can't a seller say that?
because there's a contract between the seller and I.
Yeah, but I'm talking about a closing. We're closing on the house. What's that contract got to do with my closing?
No, I mean, the listing agreement is between the firm and the
Yeah, I get it. But the seller's closing on a house. The listing agreement doesn't have anything to do with the closing on the house, does it?
Yeah, because it says that the commission is due and payable at closing.
Okay, fair enough. Fair enough. That says it in the listing agreement. I'm still closing on my house. There's two separate contracts, right, Amy? There's two contracts going down the track at the same time. Neither one of them is dependent on the other, right? Right. So you got a listing. So either one can derail and not affect the other. Meaning, like, I mean, this happens, on a regular basis, right? You got a contract and the buyer backs out because during due diligence period, right? So the contract goes off the rails. The listing agreement still keeps going down the track, right? Mm-hmm. Same thing happens when it's with an offer to purchase, right? You have an offer to purchase contract that goes down to closing. Even if he says it's a lawful order for the seller to say, I'm not going to pay commissions. That doesn't mean he doesn't owe commissions to your listing agreement, right? Mm-hmm. Does that make sense? And so, like, your listing agreement, he could fire you as a listing agent, or however you could dissolve the listing agreement, but that purchase is still going to go through. Right? Two separate agreements going down normally they finish off together, but they're not dependent on one another. And this is what contracts are, right? This is what we're talking about, what contracts. Terrence, what do you mean listing agreement? Yes, it does. We sent the percentage to the attorney. What do you mean by that?
So we make sure that the attorney is aware of the percentage to be paid out at closing, and it's all listed on the closing documents what's going to be paid out. So that is sent to the attorney prior to the day of closing.
Yeah, but that's a nicety. That doesn't have to be. I mean, that's not obligated within the contract, is it? Because in the contract,
which contract? Which one?
In the offer to purchase. There's nothing in the offer to purchase that says commissions have to be paid.
No, but it's something in the listing agreement that says it has to be. Go ahead. I'm sorry.
No, you're good. I'm sorry. We're just talking over each other.
Yeah, we're good. We're good.
Go ahead.
Yeah. So of course the contract, the listing agreement is to bring the seller ready, willing, and able buyer, right? So I brought the ready, willing, and able buyer within the time frame of the listing agreement. I'm owed that, and then so I'm sorry. Go ahead.
Totally agree. You're owed it.
So then we marry those two documents once we send it to the attorney, and the attorney.
No such thing.
Okay.
That's where you're off. There's no marriage of two competing contracts.
They're not competing against each other. They're cooperating with each other.
No, there's no such thing. There's no cooperation. There's no competing. They're irrespective of each other.
Okay.
You actually earned your commission at the time that you brought the buyer. You didn't earn it at the time that you close, right?
Right.
The seller owes you the money right from the time that you brought the client to him.
Right.
Yep, you're owed that. That's part of that agreement. Offer to purchase has nothing to do with it. Now, it's nice and normally works out that way where we go to closing and everyone's paid, but it doesn't have to be that way. That's bringing that example up is to try and emphasize the understanding and knowledge of contracts and how they actually work, right? And they're not unilateral; they're bilateral. So it takes two parties. Like Terrence, can a seller just ask you? Can a seller fire you?
Yeah, of course. Yeah. She or he can fire me. Absolutely.
No, not without you allowing it.
Well, if they find that I'm not doing what I'm assigned to do or what I contracted to do, they can.
Well, they cannot fire you. Now they might have disagreements and they might want to settle it and say, hey, I want to get out of this because you're in breach of this listing agreement, but they cannot unilaterally fire you.
Okay.
It's a bilateral agreement, guys, right? Contracts are bilateral. It takes both parties to agree. That's why when we talk about things like earnest money, here's one of the mistakes that people make when it comes to earnest money, right? Is that, hey, if they're in breach of contract on it, seller, you're going to get the earnest money, right? Or buyer, if you get out at the due diligence period of time, you're going to get your earnest money back. Those blanket statements are not true. Now, you're supposed to get it back, right? So when it comes to earnest money, you're supposed to get it back, buyer, if you get out of the due diligence. But if the seller doesn't sign for the release of that earnest money, then the holder of that earnest money cannot release it, right? It takes both buyers and sellers to agree on the disposition of earnest money by law. So if the seller just says, well, you know what? I hate that buyer and I'm not going to release that earnest money. Well, then if it's your firm or an attorney holding onto it, they can't release it. The only other way they can get it released is if a judge orders it to happen, or they can send it after 90 days. As you guys know, you can send it to the clerk of courts and they can hold on to it. Does that make sense, Terrence?
Yeah, it does.
Yeah. And so, yeah. Okay. So good. So there's good.
Mm-hmm.
Let me get back. Did I miss any questions? Yeah, Linda, you're correct. You'll have to bring legal, you might have to bring legal action and you'd win. And actually I've heard of cases where they have won on these things. You don't send a listing agreement to the attorney if the seller. Yep. Okay. Perfect. And maybe someone had a question. Yeah. Rafe.
Yeah. So, I mean, we hear what you're saying. The question, I think it was, the question that you posed before, which was, is it a smart thing to do? So, I think that's where, you made the question kind of tricky. I did say that it was a smart thing to do, although obviously, I was wrong. But the reason why I thought, and you did trick me, so I'll give you props for tricking me on that one. Because, that's basically what real estate questions are supposed to do. When we take our tests, that they're it's not what's the right answer, what's the most right answer, right? A lot of times there are answers that are sort of right, and then there's another one that's more right. But anyway, the reason why you tricked me on that one was because you said, is it a smart thing to do? Now, in practice, I know that you practice. So in practice, a lot of listing agents will say, hey, I'm not going to change the status on MLS and until we receive the check. Now, is that a smart thing to do? I think it is a smart thing to do. Now, does it align with the contract? Well, maybe not, but is it a smart thing to do? It is a smart thing to do.
Well, in our MLS, you'd be prevented. You're not supposed to do that.
Right. But a lot of listing agents will do that, and it's understandable that they would do that because there are a lot more complications on the seller side. If the buyer backs out, first of all, they've changed status. Now they have to go with the stigma on what happened. We have to go back onto the, go back on MLS, what happened, they have to go after the buyer for the money. I mean, it's obviously a lot more complicated for the seller, which is why a lot of listing agents are obviously doing things like this. Now, if you ask me, I'll say, is it smart? I mean, I think it's smart. Is it within within the rules? Maybe not, but if you ask me,
all right, people. I mean, people. Hey, Rafe,
it's smart.
I'm with you that people will run red lights every day, right? I get that. Right. So I can only talk to what you're supposed to do. Right. And so, your license would say in fact, your license, and people have been disciplined on this, is that your license is to portray an accurate position of what that property is, because what's happening is like, we're not the only ones used, right? Long gone are the days where just agents are getting the data, right? So appraisers, everyone's using the data that we're inputting on there. And so it is very important that if it goes under contract, it goes under contract at the day that it states, right? All these things like the financial contingencies, what kind of lending, all those are very important information because it's all going into the mix for where we're talking about on it. So I am with you because I do know it. And we have folks on camera and stuff talking about the things that they do. I hear it happening out there, but I got I got to teach too what the right thing to do is. But I hear you. I hear you, Rafe. I hear you. All right. So,
And lastly, simultaneously, I mean, sometimes it does take listing agents a couple of days to change the status on MLS, and not because they're doing it for that reason, right? So, I mean, it happens all the time. So, I mean, I think that if people are being reasonable, if people are working hand in hand, all these timelines kind of blend in together,
I hear you. Hey, Cindy Hansen, good to see you, Cindy. Wait, you caught my attention because the last thing I just saw on here, you said you don't allow inspections or appraisals until the monies are received?
No, we send them a welcome letter and says that they can schedule their inspections and appraisals once they've turned in their earnest money and their due diligence money.
Okay, so you cannot do that.
Oh, okay.
Because you're inserting your own stuff into this contract. Remember, they have a due diligence period of time. That buyer is contracted and paid for a due diligence period of time. You cannot restrict that. And
but aren't we not representing our sellers in the best way?
You're representing the sellers according to your ability in the law and within the law. And you cannot restrict that amount of due diligence period of time. So if they contract for 20 days, you can't say, well, you only get 10 because your due diligence didn't show up. What you need to do, and that's what I started this with in the beginning, is that what you need to do is you've got to send a letter to the buyer and say, you have one banking day or you're in breach of this contract. That's what you can say. And then you can cancel the contract if they breach it. But you can't make up stuff regarding this contract just because you want to you want sureties out there. We just can't do that. And that's where my emphasis for the last 30 minutes has been, is we can't make crap up. And this is why complaints are going through the roof, because agents are just trying to think like, well, I'm the smart guy in the room and I'm going to try and figure out how I'm going to protect. Remember, you don't own the seller, right? I mean, you are a facilitator of a contract. And you can tell, obviously, I get excited about this. I'm a broken charge just like you with agents and stuff as well. We cannot just make up rules. And we have to understand that we got a contract in place for a lot of money. So if someone, imagine, Cindy, someone pays $20,000 for 20 days of due diligence, and you prevent half of them because a check didn't arrive in the mail for 10 days. I'm going to tell you, if I was that buyer, I would sue you for every day that I missed. I'm just telling you what I would do, because I paid for it. I'm not suing you, Cindy.
I know we haven't had that problem, and we get our due diligence money in and get it in rather quickly. And we would extend if we needed to allow them the days to do it.
No, hey,
but,
this isn't your job to extend this.
Okay.
It goes to Rafe. Hey, people are running red lights. This is the problem. Like, it's never a problem until it's a problem, Cindy, right? So you've been getting along, you've been doing, and and thank you for sharing, Cindy. Is that, I mean, I'm obviously not elevated because of what your particular.
No, that's fine. It's good to know.
What I'm saying is, if it becomes a problem for you, if I'm the dude who's going to sue you and your company, that's when it becomes a problem, right? If I get cut off, I'm telling you, I'm a buyer, I get cut off, I'm going to sue you for every dime that you've cost me because of that. And if I don't get this house because I don't have enough time to get my inspections and everything in, I'm going to sue you for even more. Okay. I'm just telling you the way. That's real world right there. It's just that you haven't gotten caught up in that yet. So just be wary of that stuff. Be wary of running red lights. But Cindy, thank you very much for sharing that. That gave me a great opportunity to talk to you about that. Thank you, Cindy. All right, so we're talking about let's kind of get through this thing. So we've already talked about it being a deliberate agreement between two or more competent parties. Competence is usually I'll talk about drunks and minors on this, and so now it also happens to do with duress. So for instance, let's see. Valerie Warren. Valerie, I told you my mom passed away. Before she passed away, she was in the hospital for 2 weeks prior to passing away. She would be under duress during that time she was in the hospital. Would you agree?
I agree.
Yeah. And so if a contract was to come in on her house during that time, It could be there. There's a status that we call with a contract. Okay, so a contract can go into 3 different forms: valid, which is like most of our contracts, right? Void, which means it was never a contract to begin with. Like if I said to you, Valerie, hey, I want to buy this house because I want to set up a shop for my crack business, right? That would be void to begin with, okay, right, for legal purposes.
Right. Or voidable.
Or right. So that's the third one. That's the third one, which is voidable. So under duress, if my mom signed documents during that time she was in the hospital, then it would be considered, as you just said, voidable, right? Meaning one person, one person is able to void that contract out at any point during the contract. Does that make sense?
It does.
Okay. So now let me give you an example. I have a 13-year-old son. If my 13-year-old, you got a house for $500,000. My 13-year-old son has $500,000 in cash, wants to pay, Valerie, pay for your listing. Can your seller go under contract with my 13-year-old son?
No.
Why?
Is he's not of legal age, correct?
That's correct. He's not of what's called legal age 18, but can he still buy the house?
Technically, yes.
Yes, he can. Yes, he can. But it's a material fact that he's 13. But it becomes what? What kind of contract?
Avoidable.
Avoidable contract. That's right. It becomes a voidable contract on it. Now let me ask you one other thing. As far as drunks and minors go, some of these folks that are on this know with me on this that by 7 p.m. I might have a drink or a cocktail by 7 o'clock at night. If I'm your seller and you call me up and say, Steve, hey, great news. The buyer just sent over an offer that has everything you want it to be. It's exactly the way you want it to be. And I say, you know what, Valerie, that's awesome. I'm just finishing up a bottle of wine with my wife here. We're gonna celebrate, and I'm gonna pop another bottle. And then when I get home, let's go over that contract and I'll sign it. Now I'm already telling you what, not necessarily drunk, but what is it?
It's a possibility that you may not be coherent enough to know what you're signing.
Yeah, right. And it opens up the door of being a voidable contract, right? So the response should then be, you know what, we'll circle back and have a good night. Enjoy your night. We'll circle back the next morning and we'll sign everything then, right? To avoid the voidable opportunity that was on there. Stay with me on this too, because I want to make sure we get this out. So let me ask you this. I'm of legal age. I give you $500,000 and you give me the deed to your property. Okay. You sign over a deed to my property. I give you the $500,000. Did you just sell me the property, or do we have to record it?
It has to be recorded.
I'll give you one more chance. I'm
sorry, my window's up. You said you'll give me one more chance.
Yep, I'll give you one more chance. You just gave me the deed. Do I own the property?
Okay, yes, you do own the property.
Yes, I own the property. Do we have to record? The answer is no. There's no such requirement that I have to record. I own the property. Now, there's a reason why we record, though, and that's why we're getting to. So, Valerie, if the reason is you sell me the property for $500,000, but then you also sell it to Chris Anderson, and you give him a deed. Okay. Now, who owns the property, Valerie?
Now, whoever is recorded, who gets it recorded in their name.
That's right. Whoever gets recorded first, right? Okay. And that's why what we're called, North Carolina, it's called a pure race state, which means that it's a race to the courthouse to decide who owns it and who would have standing for any recourse. Does that make sense?
That makes sense.
That's the reason. And it's under the statute of frauds that says that has to happen in order for there to be standing, right? So I could take possession of I got the deed. I can go and start using the land. I could do whatever I wanted to. But if Chris comes back and says, I own the property because I recorded it and I own it, well, actually then Chris would own it, right? Right, makes sense. Now, the same thing goes when it comes to closing of this is why the last step the closing attorney does is the recording, right? So the attorney collects all the funds and make sure, right? They even take all the signed documents, send it up to the lender. If there's a lender involved, make sure that the lender approves all the documents as signed as is. And then the very last thing they do is make sure, if I'm closing with you, the very last thing they're going to make sure is there was no Chris Andersons in the world that got that deal before me. And then he's going to record it in my name. And only after that point that he records it in my name can he then release funds back to you, the seller, back to the agents and everything else, whoever needs to get paid money. He can't release funds for that because that's under the law it's called the Good Funds Settlement Procedures Act, meaning all the funds have got to be in here and the attorney's got to record it before he can release funds out. He's got to prove that I own it. He's got to record it saying I own it, and then the deal's done. Now I can go ahead and send the money out. Is that all good?
Sense. Yep, all good.
Awesome. And that's why you're not supposed to get keys until that's recorded. All right. And I already know Rafe is going to say, what are you talking about, Steve? I give keys out all the time. I'm like, yeah, okay, Rafe, I know how you roll. All right. Legal consideration. Jenny Purnell. Jenny, is every house in North Carolina sold as is?
No.
One more try.
Yes.
Yes, it is. Yes, every house is sold.
Understood me.
Yeah, I did. I misunderstood you. So yeah, every house is sold as is. In fact, it says in the offer to purchase it's sold as is. And so let me ask you another follow-up question. This is regarding some actions that agents are taking. Now, if an agent puts in the MLS sold as is, right? Like an agent comments, Jen. Do you look at that house, if you were like a buyer's agent, would you look at that as a negative statement, a positive statement, or a neutral statement?
I would probably look at, it depends on what the photos look like, I would imagine, as far as whether
they've been photoshopped, Jen.
Yeah. I think it's probably considered negative.
Yeah. So, I mean, and now I know people are going to say, well, Steve, it could be positive. Listen, hear me out here. So you're thinking what's got to happen with the property? What are you thinking when they say as is? If they actually put that in the comments,
that it needs repairs.
That it needs repairs.
Mm-hmm.
Right. It's not in the best of quality, right? All right. So that's an industry. If I took a poll industry wide, it'd be overwhelming. People would agree with exactly what you just said. If you're going to do that, you actually got to have written permission from the seller to advertise it as is. Because what you're now doing is limiting the amount of prospects to come into their property, right? You're actually advertising a negative, which is well known as a negative. Now I know there are some of you folks go, well, Steve, it might actually solve problems because we might not get all, it's going to only get the people in there that are seriously about wanting to rehab a building. And I'm just here to tell you, A, you got to advertise it, but B, our job is actually to get the most people in there into that property. We're to market the property, right? Now, maybe it is a strategy that your seller's like, hey, look, I don't want a bunch of people in here who's not going to look at my house and maybe, not offer me anything and stuff like that. And maybe that's valid, and that's a valid thing that you want to do. Fair enough. I'm going to tell you though, in today's environment, I just can tell you from experience is that buyers are willing to pay like crazy dollars for homes in any condition today.
Yeah, as is doesn't necessarily mean anything except I know I can sell it and not do anything right now.
Yeah, and so we have to, the point about it being, Jenny, is we got to be cautious of this stuff because again, it's never a problem until it's a problem. If the house doesn't sell, right? If the house doesn't sell and all of a sudden, it comes up, feedback is like, well, you said it's as is, I'm not going to show that property, right? Right. A complaint, guys, like I said, the genesis of this is the complaints are up 300%. A seller thinks they got the best deal. Every seller right now thinks they got the hottest thing in the market. I mean, every seller thinks like, you don't know what you're talking about. I want $1 gazillion for my house. And you're like, dude, it's like a bungalow. And so, but that's what they think. So if you don't sell it in a week, they're like, what's wrong with you? That's what they're thinking. What'd you do wrong? Why aren't you doing something? and they're going to complain about it. Again, I'm not saying that you're wrong in what you're doing on it. I'm just saying that that's where we're going to go. And Real Estate Commission says if you're going to advertise it that way, then you need to have written permission from it. So thanks, Jen. Thank you, Jenny, for doing that. I think we're all done with that. Let me just make sure I've got consider lawful objections. All right, we're good, guys. Take a break. We only got 1 hour left. We'll see you soon. All right, so let's see. We got most of the people, or we got a lot of people, I guess, that have already answered the poll question on this. So if you haven't, I'll give you about 10 seconds to answer that on it. So the question here is, with a buyer agent calling and giving you details of a potential offer, the question is, must the listing agent present that to their client? So here, let me share you the results on this. Okay, so those are the results on it. The answer to this is true. True. The listing agent is required to share that information with their client on it. And here, there's a couple reasons for it. One is a logistical one. One is simply saying that the Real Estate Commission is saying you need to share all pertinent information with your client on it, which this would be pertinent information. Is that, let's just say after class today, you're going to go show a house at 3 o'clock, and the seller has already got on there all offers by 5. So you get done with showing at 4 o'clock. You call up the listing agent and say, look, my buyer wants to make an offer on this house. However, I'm not going to be able to send you that offer until 6 or 6:30 tonight. And here's the parameters of the offer. Well, the seller might want that information. That might be the best offer coming on that property. And the seller be like, heck yeah, I'll wait till 6:30. I don't care. I mean, 5 o'clock was an arbitrary time. That makes sense. So that's why we're going to present all that information to our client, even if it's verbal. Of course, it has to be in written in order for it to become a contract, but you're going to present that information to them. Let's see. Okay. Perfect. All right. So we're on the cyber. Any other questions on the contract stuff that we talked about? Anyone want to shout out anything? Okay. Cybersecurity, guys. On this, we've been talking about security, I guess, for the last 4 or 5 years on stuff, more particularly in regards to personal confidential information on it. And that the Real Estate Commission is more trying to bring real estate in towards more HIPAA style kind of protections. So here, let's go through a couple of these vignettes on here.
Christy, a broker with ABC Realty, is updating documentation and transaction file while at a local coffee shop. Christy uses the public Wi-Fi and sends her client a reminder via email to sign the engagement letter for the closing attorney's office. Due to Christy working with this attorney previously, she also attaches a copy of the firm's wiring instructions to the email to her client.
All right, so you got the scenario. The question is, what did Christy do wrong? Go ahead and throw that up onto the chat there. All right, Amanda, out of the box. Don't email wire instructions. That's great. Forward wire instructions, yeah. Great, Chris Anderson with public Wi-Fi. All right, guys. So good. So you got it down. It looks great. All right. So a couple of things. One is the public Wi-Fi. Commission has said over several times about the use of public Wi-Fi when it comes to confidential information. Now, you look at the wiring instructions on that, and particularly the attorney information sheet. Last year, we gave a real example that took place in North Carolina, where a buyer's agent did exactly the same thing and forward the wiring instructions on. All they did was forward the wire instructions on. And the buyer sent the money, tried to send the money to the attorney. It got snapped up somehow by virtue of the bad guy got the email that was going to the actual buyer. Anyway, the loss to the buyer was $185,000, and the firm was responsible for 165,000 of that loss, right? So that's a chunk of change to lose on it, which is what actually prompted me in our company. None of our agents are allowed to forward instructions on. They're not to deal with the wiring. They're not to deal with any of the attorney's information instructions at all. The only information our agents are allowed to provide to attorneys, I'm just telling you this, it's not like a commission thing, is anything to do with commissions or anything to do with our agents' involvement with it. Like, hey, here are some receipts or something like this that are part of it, or here's the American Home Shield contract or something. But any of that other information has got to go directly from the attorney to our client. And then we tell our client that any wiring information needs to be done over the phone with the firm. So that's just our way of trying to minimize our exposure to the potentials of fraud and stuff regarding that. So let's listen to the next scenario here.
Sandra, a broker with House Realty, uses her smartphone to access transaction files and client information. One day, while Sandra is searching for listings, a text message pops up with a link to set up delivery preferences for a package. Sandra does not remember ordering a package, but she clicks on the link anyway.
Y'all clicking on links. What y'all doing clicking on links? Ain't nobody got time for clicking on links. Have you all been bombarded with like links and text messages from nowhere coming to you? I don't know if I'm the only one, but I mean, I'm getting text messages from all over the place on stuff. So anyway, this was just saying, hey, if you don't text, don't click on a link if you don't know what it's from. Let's listen to one other.
Joe, a BIC with Farm Realty, answers a call one day. He receives an unfamiliar call from Tom, who claims to be a representative with the firm's cloud storage provider, Documents or Us. Tom informs Joe of a new upgrade, and during the conversation, Joe states the firm is not paying for an additional service. But Tom convinces Joe that the upgrade is needed and it's free. Joe then provides his email address, receives an email with a link, and clicks on it.
All right, similar kind of thing. You get an email, clicking on a link, they're saying no. Don't do that. These are just kind of warning signs of bad things to happen. So let's go over a couple of things that they want to make sure that we cover under cybersecurity and stuff. And as business owners. So one of the things they want to make sure is, look, if you're a firm, so you're storing data. They want to make sure that if, as a firm, you're either storing data that's protected in the cloud, meaning, you have some type of encryption or ability to encrypt on some of the stuff. Now, it doesn't have to be for everything, right? So, for instance, I've got two Gmail platforms. We use in our company a Google business platform that does have encrypted emails and all this kind of stuff. And then we have I have me personally have a Gmail account. Well, if I'm going to send to a client, hey, see you at the inspection tomorrow at 2:00. That doesn't need to go through Gmail or anything like that. That can be on a text or whatever. But if I'm going to be sending documents to get signed or to store those documents, then I need to have it in a protected area. And that's kind of where the commission was saying on, is to limit exposure. Now, I'm not the IT guru, but I do understand how to follow orders and actually know a little bit about it as far as protecting this stuff. If you're using zip forms, you have the ability to encrypt, and that information is being protected. It's protected online as well. If you're using .loop as a means of getting signatures, or e-ink or DocuSign, those are all being protected and stored on their facilities. All cool. Now, one of the things you want to be aware of where it becomes unprotected, for instance, it's like if you're on DocuSign and you've checked that you want to get the email of the document once it's fully signed, and you send it to your Gmail account, right? So you remember, how that works, right? The last person signs, and then you get emailed automatically that signed document to your Gmail or Hotmail account or something, an unprotected, open-ended public type of email account. Well, that's what the commission says they don't want to have happen. So they don't want that document to, that's got, remember, an offer to purchase contract's got, hey, this is how much I'm selling it for. This is where, here are addresses, here are dates and stuff that are on there. So, and that's just using that one document, right? You got appraisals and all this other stuff. They would prefer that you either send it through some kind of secure means when you're dealing with that. They've also said, especially with agents that are working for firms, that they recommend that they have a portable hard drive to store their copies of their files. So you might have a CRM device or something like this for your firm, where agents are sending all their documents for review, right? So like an agent's, if they got a house under contract, they're sending it to some place in the cloud of yours, maybe, for instance, secured. But remember, they need to have a copy, because if they don't stay with you, remember that copy's got to be retained for 3 years, starting from the point that you close on that transaction, or the last time you have a dealing with that particular person on that transaction. And so that's why one of the reasons they wanted to do it is they recommended the portable hard drive separate from yours. And also because I guess they're going under the assumption most people's emails are like Gmail or Hotmail or whatever, AOL, or if that's still around or whatever. So that's on the cyber security side. All right, so we're all done with that. Any questions on that stuff? All right, we're moving on. Now this is the section for you guys, for the BICs specifically, which is about PBs.
15 full brokers and 3 provisional brokers, PBs, are affiliated with XYZ Realty at 123 Main Street. Sally is the BIC of the office. Sally allows brokers to work as teams within the office, and Hank, one of the full brokers with XYZ, has formed a team with 2 other full brokers to work together to increase productivity. And they're calling themselves the Hankster team of XYZ Realty. Hank wants one of the PBs to join the team. Is that okay? Why or why not?
All right, so the question is that okay for the PB to join that team? Yes or no? Just go ahead and type that in, yes or no. Yeah, Tara Adams, you said yes, but the BIC would be responsible for mistakes. Just can you just expand on that a little bit?
Yes, so they could join a team, but the BIC still has to micromanage them and oversee their documents and their advertisements, because the broker that's on their team can help them, but they're not responsible overall if they make a mistake.
Right. So Sally, the broker, is still ultimately responsible for them,
Yes.
right? Okay, perfect. Thanks, Tara. All right, let's look at this one other example on this. Here we go.
The Hankster team of XYZ Realty is growing fast, so Hank decides to create an entity for the team. Hank creates and registers the Hankster Team LLC with the North Carolina Secretary of State and obtains a firm license from the Real Estate Commission. Hank and his team members continue to advertise as the Hankster team of XYZ Realty.
Now the question here is, can a PB join this team? Yes or no? So the difference between this and the last one is that now it's an LLC. Okay, so we got a mixed bag. Thanks, Joe. Good question. Okay, so let's go through these. There's 3 scenarios we usually talk about when we're talking about teams on this. Teams are obviously very prevalent, and there's been a decision made last July to help improve teams. So a team, like the first example. So let's just start. When I started my business, 40% of my business was, I live in North Raleigh, was in Fuquay Varina, if anyone knows about it. So that was a haul. It might as well be in South Carolina for me, but I was traveling back and forth to Fuquay Varina. I ended up teaming up with a young lady who lived down in that area, and she ended up doing that business down there, and I did business up here. We shared in some postcards when we used to do all that stuff. That was the first kind of thing of what a team would be. You just kind of pool resources together, and there wasn't anything special that you needed to do. The second scenario that we've always talked about is then the Real Estate Commission, and you all know this stuff because you're BICs. The Real Estate Commission carved out a thing in order to get paid directly from the firm to another firm, right? I wanted to be paid as, I wanted to start a company. And so you start Steve Inc. or Steve LLC. And that way, Remax could pay my firm, and then my firm could pay myself, right? I was doing enough business that my accountant said, Steve, you ought to start a firm on it and have the firm then pay you as an employee. And the real estate commission said, hey, that's cool. You don't need a BIC, right? As long as it's for compensation purposes only. Kind of like what Tara was saying just a few minutes ago. Well, now I could have brokers on my team, right? I could have brokers working with me, but they would still be paid by Remax, for instance. You can have a PB working for you, kind of with the team, affiliated with the team. Well, once you decide you want to advertise we're not advertising Steve LLC. We're going to advertise North Carolina's best real estate company. Okay. Well, once we do that, we're a DBA, for instance, right? We got to get approval for the DBA. We have a firm license, but once we start to advertise that way, now we got to have a BIC, right? That's what you're saying, right, Tara? Now, I think, right? Okay. And so now we got to have a BIC. So now Steve Henion is got to be I'll just choose this in my example. Steve Henion is the BIC for North Carolina's best real estate team under Remax, who has, let's just say the BIC for Remax is Tara Adams. Okay. Well, a PB could only work for one broker in charge. So if a PB was working with Remax, then that PB could not work for North Carolina's best real estate firm. Is everyone good with that? That's why I think we have a mixed bag here, because what happened was in July 1, the commission realized that, hey, a lot of these PBs are getting business from these teams, and it's posing a problem of who are they actually affiliated with and who's going to be responsible for them. Okay. And there was some confusion, and because of complaints, they were addressing this confusion. What they decided, which is great news, is that they said PBs can be dual affiliated now. So a PB can have two brokers in charge, provided that both firms are at the same location. Okay. So the gist being, they said, okay, you can go ahead and join North Carolina's favorite real estate company under Remax because they're both housed in the same building. So basically both BICs have access to that particular PB and all their actions. Now what goes with that is that both BICs are equally responsible for all the actions of that PB. So, if something goes south with the PB, if the PB causes an error, the Remax broker in charge and Steve Henion as broker in charge would be both responsible under the eyes of the real estate commission. Training for that PB. And next year, guys, there's going to be a whole bunch of stuff on actually the responsibilities of BICs with PBs, because as a whole, we're shirking our responsibilities, especially when it comes to training and the requirements of that. But in any event, both are responsible for the advertising that's being done. Now, remember, in that scenario, guys, and maybe some of you might fall under this. Maybe you are actually the BIC of your firm under another firm. You might be, Tiffany Elder LLC under Caldwell Banker. If that's the case, then on all of your agency agreements, you've got to list both firms. Both firms have to have be on the listing agreement and the buyer's agency agreement, which also means then both firms have got to be on all advertising. So anytime you do an Instagram photo or a tweet or you post something up on Facebook, or you got a flyer at the house, you got to have both firm names posted on all that. Questions on this, on the PB stuff on that? Anyone? That's Tom, what's your question? Tom Smith?
Hey, Steve, it was, you gave 3 scenarios of teams, and the second scenario was an LLC that was created just for compensation purposes.
Yeah.
Does that have to be registered with the North Carolina Real Estate Commission?
Yes. Yeah. Good question, Tom. So, right. So if you'd have to have a firm license with the Real Estate Commission, right? So you register kind of like in, I think it was scenario 2 here, was you get your, you register your business with the Secretary of State, North Carolina Secretary of State, then you apply for that firm license and you get that firm license that'll allow you to do it. Yep.
Very good.
Cool. Any other questions on that stuff, guys? Nope. Hearing none. Okay, cool. All right. You look thrilled. Hey, Valerie, you look great. All right. We're almost there, guys. All right. Let's go into law and rules.
Lisa, a BIC, opens a trust account for her real estate office at the local bank. Must Lisa take the commission's trust account course? Yes or no? And if so, when must she take the course?
You guys should all know this. So if they take, if they open up a trust account, do they need to take the real estate's commission's course? And if so, how long do they have to take it? Go ahead and type that in if you don't mind. All right. Dom, you got it. Yeah, it's correct. And Nigel, you got it. Good job. It's yes, you got to take it, and it's got to be within 120 days. Good job, Tara. Good job, guys, on that. Hey, a little FYI, is there anyone with a show of hands who's holding a trust account? Not if you're not, I don't want to ask if you're property management, but if you're non-property management. So Dolores, you've got an account, and who else do I say? Leslie, do you have it? Leslie Nichols? No. Is there anyone else? I'm scrolling through here. Nope. Okay. Well, it's an interesting thing, right? So we have a complete shift of where we are with trust funds and whether we're holding them or not, right? Back in the day, everyone had a trust account because that's what you did. You held on to their earnest money. Now we've kind of put that on to the attorneys. I'm giving you like a heads up that the commission, now they've punted on this a couple of times already, but the non-commission members have really been thinking about, right now, like when you go to renew your license, your firm license, it's asking if you have a trust account. Have you done that yet? If you've gone to pay your $45 for your firm, one of the questions that you have to answer is, do you have a trust account? Okay. Now there's a reason they're asking that, is because over the years, I'd say over 5 years, they've been trying to push every one of us to be required to have a trust account. And the staff at the Real Estate Commission has been pushing back saying, no, we don't want to do this. Let the market kind of figure it out. But that is one of the reasons why they're asking, because they're trying to find out how many people are actually doing it. And the reason for that is there's a small group of attorneys who are complaining that they're holding on to these earnest money. And it's become a what do I want to say? A competitive situation for attorneys, right? Because if an attorney's holding earnest money, you're going to go to them. That's one of the things you're going to go with a lot, right? Most people don't hold on to it. They're going to go to an attorney that holds on to earnest money. So that small group is complaining. Small group of attorneys that doesn't want to hold on to it. So I'm just giving you that out, because the same small group of attorneys did get something given to them that takes effect on July 1. This is not in your course material. Okay. This is going to be rolled out, and it hasn't even really been advertised by the Real Estate Commission. It'll come out in next year's update course, which comes out in 3 weeks. I don't know if any of you do this. We do it. We do it at our firm. We have a thing, what's called table funding. Are you all familiar with the term table funding? Table funding, if you're not familiar with it, if you've worked at Remax or I'm sorry, Keller Williams and some of these other places, this is where our company got it from. But table funding is basically where the firm asks the attorney, instead of sending the entire commission check back to me, the firm, go ahead and split the commissions per X. Go ahead and give, excuse me, go ahead and give X agent their $8,000 commission and give the firm their $2,000 in commission. And the attorney cuts 2 checks right there at the commission table, basically, because it saves time for the agents, right? I mean, the agent gets the money immediately at that particular time. In fact, with our company, the closing attorney we recommend, they wire the money to us. I mean, there's no checks involved at all. It just gets wired to you. So starting July 1, the Real Estate Commission is prohibiting that act. And it's going to raise a lot of cane, especially for the people who, like us. I mean, I've already been in contact with them talking about this, and even whether they can legally do it is in starting July 1, all money is going to have to flow through the firm, and then from the firm to the individual agent. Okay. Now, if you're another firm, so let's just say, let's say you're with I've got Home Coach, LLC, and then there's Tierra LLC. If Tierra Belizaire LLC is a firm, then I can ask the attorney to split checks. But the attorney is going to be prohibited from splitting check. Well, actually, your license is going to prohibit the BIC from asking the attorney for splitting checks to individuals. And that's going to be a big shift in what a lot of people in the state actually are familiar with. And that also includes referral fees. So if a referral fee is to be paid to an agent, where, in my firm right now, if you got a referral fee from, Chattanooga, Tennessee, and we're not taking any money out of it, that can be paid directly to you. I could care less whether you get it or not. It doesn't need to come to us. Starting July 1, that money is going to have to come to me, and then we're going to have to pay it out. And then that becomes then part of the 1099 process that you would be doing. Any questions on that stuff right there? Dorothy, you said crazy. Dom says nice step backward. Dorothy, what do you mean better paper trail?
Because I guess with everything going through the firm, it'll be easier to trace monies rather than having to go to lawyers to trace monies.
For what? Like, what do you mean?
If ever there's a dispute.
Oh, okay. Okay, cool. Thanks, Dorothy. All right, so let's go to the next scenario here.
Chandra, a pre-licensing student, tells her instructor that she had a criminal conviction in her past and asks if it will prevent her from being granted a real estate license. Her instructor tells her she can petition the commission for a decision about the conviction prior to completing the pre-licensing course or prior to taking the license examination.
So is that true? Is the instructor correct on that? Can they petition to get their criminal records check reviewed before taking the test? Yes or no? All right, so we got a mixed bag. So guys, the answer, so the commission has each year averages about 350 folks that this becomes an issue with, where their background check impedes them getting a license on it. And so, or at least has to get reviewed. And so the commission has gone ahead and said yes, to avoid someone having to pay and take the test if they're going to get rejected anyway. They said you can go ahead and get a review before you go ahead and take the test. So it helps that small amount of folks out on that, on it. All right, one more thing on this section.
True or false? Pre and post licensing courses may now be taken in an online, self-paced environment.
True or false, guys? Can pre and post licensing be online? Just say yes or no. Yeah. So here's the thing. With COVID too. So yes, pre-licensing and post-licensing can be offered online. We offer both pre and post-licensing and courses. Now, here's an interesting thing, guys. During COVID, the commission suspended all classroom testing. Okay, so even though everything was online, they suspended that until April 11th. Now, which means all they could do is they just had to take like the 75-hour self-paced course. They had 6 months to complete it. They could go directly to the state exam. On an average year, the pass rate for the commission's test is about 50%. Okay, 50%. Those who take it, about 50% completion on that. Do you know what the pass rate now, at least up until April 11th, because they didn't have to take a test, pass rate was just shy of 20%. Just shy of 20% on that. And you can imagine why. Now, they don't have any data. I've been trying to get data from them as far as the pass rates. Is it, because you can do Zoom calls now, these Zoom classes as well. Do we have data whether it's what percentages of Zoom, what percentages of online distance learning? They don't have that data as of now, at least, on it. But North Carolina is still clear to be one of the hardest states to get a license on, guys, on that. So, okay, that's that section. Any other questions on that? We're moving right into job security free. Well, perhaps you're right. Our tutoring business has gone through the roof. That's for sure, Dina. Our online tutoring is taken off. So a lot of our instructors are actually staying on that. All right, this is let's move into this. Here we go.
Amin paid his renewal fee this year, but he did not take CE. Amin's parents now want to sell their house. The questions are, can he represent them in this transaction? And would the answer change if Amin takes his CE?
So you guys should all pass this pretty quickly, right? So if Amin hasn't taken his CE and it's gone and it's now July 1st, is he able to help his family out selling a house? Yes or no? All right, you guys got this. It's kind of a no-brainer on it. Now, let me ask you a question, though. Let me ask you another follow-up. Great, guys. It's no. Perfect. You did awesome. Not until he takes a CE. Great, Lisa. And that would make... Now, let me ask you a question. So let's just say someone in your firm, right, one of your agents, says or does not do their CE, right? So you're a broker in charge right now. You can go online and see anyone who's under your license, whether they've completed their CE or not. You can go check that out. Can you hear me, guys? Can you hear me? Yes? Sorry, my internet blinked out on me. Thanks. Thanks. I was kind of figuring I might have to join in. So if the example I wanted to give, if you're they don't do their CE by June 10th, when does their license go inactive? Valerie Warren, when does the license go inactive? Can you unmute yourself?
July 1st.
July 1st. July 1st. That's exactly right, Valerie. Thank you. Now that means you got 20 days to tell all your customers, how awful you are and couldn't get it done in the 365 days that were prior to that. But it goes out July 1st. Then you have, now here, stay with me, Valerie, on this. So if they take their CE, they're active, they become well, let me ask you this, Valerie. They're working for you. It's a PB who doesn't do their CE. They go inactive. They then take their CE. Are they automatically active? You got to unmute yourself.
Yes, within a certain time frame.
No. And the reason why, now they've completed their CE, which is good, but they have to re-affiliate with your firm. They actually have to do that extra, and you have to do that extra paperwork saying that they are going to be on with your firm. That's what will activate them to go in active status, because they have to be affiliated with a broker in charge. Does that make sense?
Yes, okay.
Okay. Now, if a regular broker, a full broker is with you and goes inactive because of CE, when they do their CE, they will automatically become active, but they're still not with your firm. You have to, again, reactivate them onto your firm. And that's one of the mistakes, guys, especially BICs. If you don't, well, first of all, if you don't, thank you, Valerie. If you don't do your CE or pay your $45, the commission gets really upset with you guys. So make sure if you go inactive or expired, right, because you don't pay, you need to re-affiliate with your firm, especially if you're a BIC. Now, the BICs are going to have to take, obviously, they're going to make you take the 12-hour BIC course again. Let's just also recap real quick with the expired. Your license can go expired until the end of the year. And all you have to do is pay $90. Okay. So on July 1, you pay your $90, right? That's twice the amount of the fee. If it goes, you got till December 31st. On January 1st, you have to pay $90 and then take a 30-hour CE course. Okay. So on January 1, you've got to take 30-hour post-licensing course plus your $90. After 2 years, then you have to start all over again. Okay. Now, listen, one of the things I want to make sure of before we say goodbye to each other is I do want to say that survey is going to come out. Guys, don't freak out if you don't see it on your personal portal on June 10th. Okay. If you've stayed on this and we haven't kicked you off or anything like that, you're going to get credit for the class. We're having these intermittent internet connections, and I wanted to make sure I got this out to you guys on that too. We really do appreciate your business out there. We thank you for choosing Home Coach. We know you guys have options on there. We're done. I'm going to sign off. Colleen's going to stay on if you have other questions on here, but we're good to go, guys. Thank you very much for everything that you've done, and hopefully we'll see you next year. Thanks for choosing us, guys.